So you're letting everyone in now. No, I should let everyone in. Okay. Just rename myself. Is he going to get the jurors? Yeah, I don't remember. There were so many. I don't know how we couldn't have gotten bakers. It's a very target-rich environment. Well, the pandemic brought the baker out of a lot of people. Had I been a potential juror during the pandemic, you would have heard about us dusting off the bread maker and doing different things that we hadn't. I mean, you're stuck at home. That's me. Okay. All right. Questions? It's the big screen. Going. A gallery. Should I try to add it through the control panel?
Yeah.
Can we get the jurors? We're ready for the jurors. Please, yeah.
Is that your water? Is that your water? Or somebody left it there?
Is it gallery? Gallery. All right, let me know if it comes on. Should be in.
There it is.
Woohoo!
Just have a couple in the restroom.
Okay, and you'll let them know they can sit anywhere, but they need to sit where there's a
So
cushion.
there's a cushion. I
Yep.
got
Great.
it. Yes. And my dentist, they get kind of restless after a while.
We have a little Fulton County swag for the jurors. Least we could do since they get $25 a day.
And free parking.
Yeah.
Free shuttle.
Our Palmer.
I just want to make sure I gave some clear instruction. I told everyone here that during lunch period, that they would be allowed to eat lunch here on the tables. Is that all right with you?
The lawyers or the jurors?
The lawyers.
This will be their courtroom at lunch because the jurors will be over
And
there.
then I explained to the jurors that they can eat lunch in there.
Yeah,
In that.
that's fine with me. If there's any mustard left on any of the tables, I'll know whose table it was and they'll come in and clean it up.
That's right, that's right.
Judge, I also want to mention that Mrs. Hyder is here. She's a part owner of the American Business Group.
Okay.
She's a defendant.
She's not going to testify.
She's not testifying.
She's welcome here all day, any day.
All right, thank you.
All right, ladies and gentlemen, all rise for the jury.
You all should take any seat you want, but that's going to be where you sit for today. So pick a spot. There should be a comfy cushion waiting for you. And you can be seated when you've found your spot. When Sergeant tells us everyone is present and accounted for, we'll.
I think we're missing a cushion.
That's the lucky juror who gets to go home. It's like musical chairs. Tomorrow there'll be one fewer cushion. Okay.
You don't make me see it.
Ladies and gentlemen, thank you for your patience. You were on time today. We were on time today. I was a little late because of drug court that was in here, but the lawyers and I had to cover a few issues that needed to be resolved before they could give their opening statements. So thank you for your patience. Probably good practice for you to learn how to hang out in the jury room while we're working through issues, because that will come to pass during the trial. That we'll need to have you step over there so we can talk about things outside your presence. I'm Judge McBurney. Here I am in the flesh. Here you all are in the flesh. It's great to see you in person. I will be wearing a mask as well when I'm not addressing you as a group. That is the courthouse policy. I know we are in the vaccine era, and it may be that most of you are vaccinated, but because we don't require people to prove that they're vaccinated, we need to default to someone may not be. And so everyone in court will be wearing masks, nose and mouth, the whole time, unless they're speaking. So the lawyers are authorized to remove their mask if they're asking witnesses questions or addressing you, or I'm having a conversation with them. Similarly with the witnesses. But if the lawyers are sitting at the table not doing the talking, their masks will be back on. And that's for your safety and ours. We have taken a bunch of steps in the courthouse to keep this safe from a pandemic perspective. We've got fancy air handling equipment now dealing in all the courtrooms. This courtroom, we've invested in some larger air purifiers as well. We've got hand sanitizer out the wazoo. So if you need it, let me know. We've got these big jugs where if you push the thing all the way down, it's like a handful of hand sanitizer. We've got that. We have extra masks if you need them, but they are the kinds you get if you go into the grocery store. They're not nice and comfortable, but we've got backups. You should bring those that are comfortable for you. And if at any time you're uncomfortable with what's going on from a public health perspective, let me know, let the sergeant know, and we'll do what we can to address it. You are not guinea pigs. This is not the first trial we've had since the pandemic started. I've already had one of these already where we picked the jury online and then you came in. But between my colleagues and me, you guys are probably number 16 or 17, and it's worked well. And at the end of the trial, the jurors have said, we felt like we were well taken care of, one, by our good deputies, but two, from a public health perspective. A side effect of that, though, means that your jury room is a whole courtroom. It's a little less personal than the jury room you'd normally be in, which is through that wall, and it's like a big boardroom table, and you have these nice chairs and your own coffee maker, your own refrigerator. That's there, it's just dusty because we can't put you all in that closed space. Maybe 6 months from now or sometime, but for now, it's a slightly different setup. You have to sit on those benches instead of the jury chairs and the jury box, but that's why we got you those wonderful Fulton County cushions. And hold on to that. You got a bag as well. And in that bag, there's a notepad and a pencil, and we'll talk about notepads in a minute, but that's your stuff. And when you're done for the day, you can take it to the other jury room. Probably better just to leave it right here, but just mark something on it, the notepad. When we reconvene in the morning, you don't have to sit in the same spot. In fact, I would encourage you to pick a different seat each day because you will physically get a slightly different perspective. The witnesses who will be testifying are way up here. You'll be able to see them on that big monitor, but Mr. Garcia, you're gonna have a great view of that monitor. Mr. Kuzniak, you're gonna have a less good view of that monitor. And so moving around, not during one day, but at the start of a new day is a good idea. Overnight, they are going to clean out this courtroom and it will be clean enough to eat off the benches. I wouldn't do that, but they will be sanitizing everything when you go home each night so that we start anew, fresh and clean. So that's what's going on from a public health perspective. And as I said, my mask will be on me once I stop talking. Before the lawyers can start all the hard work they're going to put into presenting the case to you, I need to cover a few things. I'm going to give you some basic legal instructions, and then we'll get started. But the first thing to make you official jurors, and you may have started feeling official ever since our second Zoom session last night, but to make you truly official, you have to take the jury oath. And so what I'd ask you all now to do is to stand and raise your right hand. Do you swear or affirm that you shall well and truly try the case that is being submitted to you and give a true verdict according to the law that I will be providing and the opinion that you form concerning the evidence presented to you to the best of your skill and knowledge without favor or affection to either party? Please say yes if you so swear or affirm. Yes. Does anyone not so swear or affirm? Great. It's official. One other question. You can be seated. Sorry. Once it's official, you can sit. Ms. Glass, good appointment? But you were able to make it? No problem? Okay, thank you. You'll let us know if there's anything else that needs to be done. Okay, great. All right, we are going to start the trial in just a bit. I'm going to give you some instructions. A logistical instruction that is important is that you should not come into 8D unless the Sarge or one of his colleagues is bringing you in here. So when you show up in the morning, and tomorrow we start at 9, you're going to go to 8E. That's your jury room. And so when we're done for the day, do you have stuff in 8E? Some of you have left stuff in there. Good. That's your safe spot. You'll go back to 8E, and that from there you'll be released each day, just so you can get your things, leave your things there. That way your phone's not ringing in here. So don't come into 8D unless you're escorted as a group by one of the deputies. During the course of the trial, it's not appropriate for the lawyers or the parties to talk with you outside of this courtroom when everyone is here and the court reporter is taking everything down. That means there can be an awkward situation where you're getting off the elevator and you're not sure which way the restroom is, and one of the lawyers is right there and you say, hey, could you tell me which way the restroom is? It's probably okay for them to say it's that way. But beyond that, they need to not interact with you because it's not appropriate for them to, in any way, intentional or not, try to strike up a different relationship with you or interact, because who knows what might be inadvertently shared. So if the lawyers sort of move back, like you're the ones with the no vaccine, it's nothing personal. They need to only interact with you in this formal setting. So if you have questions about where should I go to lunch, or I need this or that, folks in the brown shirt are your number one option. Asking the sergeant or one of his colleagues. You can ask me or my staff, but don't reach out to the lawyers just because you're passing them in the hallway. They should not give you lunch recommendations. They may have great ideas about where to go to lunch. When the trial's over, they can tell you all about their favorite lunch places, but not right now. We will, from tomorrow forward, go 9 to 5. Today, we're going more like 2 to hopefully a little past 5, but your schedule dictates. So if someone has a conflict right after 5, then we'll stop. And we can break, not for the day, but to take a break at any time. If any one of you needs to take a break, you can't focus anymore because of a restroom need, or you need a snack because of a health situation, or you're just losing focus because someone has been droning on, and it happens, then just raise your hand or get the deputy's attention. He'll let me know. And then I won't cut someone off immediately, but before the next question, I'll say, hey, we're gonna take a 5-minute break. That's fine. Just refreshing is fine. It's also okay. I can't remember if we have on the jury someone with a bad back. If you're on the edge of a bench and standing up is going to help you stay focused, that's okay. As long as you don't have to clap your hands when you do it, but you can sort of stand up and shake it all about and sit back down. That's not going to bother anyone. We'll keep on going through things. But I can't read your mind unless I see that your head is going like this, that you're fading. So if you feel like you're fading, before you get embarrassed and fall asleep and I have to gesture to the sergeant to wake juror 17 up, let us know and we'll take a break. All right, let me share with you some preliminary legal instructions and logistical instructions. All right, so you all are about to hear the case of D2 Property Group and the Daltons versus Donnie Hyder and Bristol Consulting and American Business Group. Before we can start the presentation of the evidence, I need to give you some preliminary instructions and talk to you about your role as jurors, my role as judge, and the attorney's roles as advocates. Most of you, from the questioning we had yesterday, I know have never served on a jury before. So some of you only know about what a jury does from watching TV. And it's not that way. It just doesn't, the way it plays on, first of all, it's shorter on TV. They fit into 30 minutes. But it's a different format and people yell less in real life court and witnesses tend not to pass out on the stand in real life court or suddenly confess. And we'll talk a little bit about steps you need to take to make sure you're not exposed to influences outside the courtroom by maybe conducting some kind of online research. And you've all been provided with notepads. You are free to take notes anytime anyone is talking. You can take notes about my instructions if you want. You're certainly free to take notes while witnesses are testifying, but note-taking shouldn't distract you from seeing what's going on. Sometimes it's real important to see how a witness is physically responding to a question. And if your head is buried in your notepad, you'll miss that. And that's not me dissuading you from taking notes. Some people remember by hearing, others remember because they're writing it down as they hear it. And you're going to do what works best for you. There's no requirement to take notes, but you're free to do so. Notes should not be shared with anyone else in your group until you begin your deliberations. It is your private journal until you deliberate. When you're deliberating, you are free to refer to your notes, but notes are merely memory aids. The fact that some other juror remembers that a witness said the car was blue and your notes say that it was red doesn't mean your notes are right. That's what you wrote down. Maybe you misheard, maybe you were dozing off, but you're free to rely on your notes to refresh your recollection and to encourage others that this was what your recollection was as to what the testimony was. When the trial is over, your notes will be collected and destroyed. You do not need to worry about them showing up on the public record of this case if you drew a mean picture of the judge or anything like that. They are private unless and until you choose to share them with your colleagues during deliberations, and then they're literally shredded. They get put in a shredder and they make a lot of green confetti. Ladies and gentlemen, in a civil case, which is what we're dealing with, the plaintiff, that would be Ms. O'Neill and Ms. Tucker's clients, the Daltons and D2, the plaintiff has the burden of proving its case. The plaintiffs must prove their case by what is known as a preponderance of the evidence. The term preponderance means superiority in weight. And as it is used in the context of civil litigation, preponderance of the evidence means the greater weight of the evidence upon the issues involved. Whatever the question is that's presented to you, you're deciding which side has presented more evidence. And to be a preponderance, the weight of the evidence must be sufficient to, and here's a legal phrase, to incline a reasonable and impartial mind to one side of the issue rather than to the other. And this is where these scales of justice that we see as sort of an icon for the justice system are a helpful symbol. If you think about the scales, preponderance means you can perceive that the scales are moving. And the plaintiff's burden in this case is to put enough evidence on their side of the scale that you can perceive that it's tilting in their favor, however perceptible it may be. It may be when the evidence is over, you think the scale thumped down on the plaintiff's side. That's clearly a preponderance. But if you believe that the scales tilt perceptibly in favor of the plaintiffs, that is a preponderance of the evidence. If the scales are even, plaintiff has not met its burden. And of course, the same is true in the other direction. If you find that the scales tilt even barely perceptibly in the defendant's favor, that is a verdict in favor of the defendants. Put differently, the plaintiffs have not met their burden. Now, the basic structure of a trial is that in a few moments, both sides will have the opportunity to present what's called an opening statement. And the lawyers will stand up and give you a preview of what they think the evidence will be. Nothing the lawyers say, and I'm going to tell you this many times, nothing the lawyers say is evidence. Evidence comes in two forms in this case. What witnesses say under oath, and the lawyers aren't ever going to be under oath, and exhibits that are admitted, like a contract, a document. That's the evidence you consider in deciding, have the plaintiffs met their burden? But in a moment, the lawyer is going to come up and say, here's what we think this case will be about. You're free to take note of that. And that's their forecast of what will be shown. But it's not proof that anything happened in this case at all. Neither side is required to give an opening. Both typically do, but it's not required. When the openings are done, plaintiffs begin presenting their case. They try to start meeting their burden. And they present that case by calling witnesses. And those witnesses will testify, form of evidence number one. And through those witnesses, the lawyers will admit exhibits, form of evidence number two. And that's when you start hearing the evidence of the case. When the plaintiffs have presented all their evidence, you will hear the magic phrase, the plaintiffs rest. We'll all sigh. There'll be some legal matters we need to take up, but then the defendants will have an opportunity to present whatever they want to. They don't have a burden in this case, and so it may be they present nothing, but they have a right to. And so it may be Mr. Kendall calls witnesses, and that will be evidence from the defendant's case. It's still just evidence, but it will be evidence that the defendants are presenting through witnesses that they call. Ultimately, I'll ask Mr. Kendall to call his next witness, and he'll say, we don't have any more witnesses. The defense rests. And assuming there's no rebuttal from the plaintiffs, the evidence will be closed. And the only two parts of the trial left will be closing arguments from the lawyers, where they'll get back up and they will argue to you what they think the evidence has proven. They will be trying to persuade you to decide the case in their favor. And they are perfectly entitled to try to persuade you. But again, nothing they say is evidence. So if a lawyer gets up and says, by golly, the evidence has shown that that car was blue, and you know full well that all the pictures show that the car was red, that's the argument of the lawyer, but it's not evidence. It's something you can note, but it's not proof of anything. When the closing arguments are done, I will give you more substantive law about the allegations in this case and the elements that the plaintiffs must meet if they are proving by a preponderance the claims that they've brought against the defendants. There'll be a few other charges I give you, and then you'll be able to begin your deliberations. You guys will go back to 8E. You'll have all the exhibits that have been admitted. You'll have your collective recollection. You'll have your notes. You will not have a transcript of witness testimony. That's not how trials work. So that's another reason some people like to take notes, but you will not be able to say, hey, could we get a transcript of Fred Smith's testimony? You can ask that question, but the answer will be no. You don't get the transcripts. So that's a reason to stay dialed in and to let us know if you're having trouble staying dialed in so we can take a break to get you refocused. During the trial, the lawyers may object to certain questions or the admission of certain exhibits if they believe that letting that question get answered or admitting that exhibit would violate some rule of evidence. I need to rule on those objections. So a lawyer will say, objection, hearsay. I may hear from the other side. I may not need to. I will either say sustained. That's a valid objection. Don't ask that question, or that exhibit's not coming in. Or I may say overruled. If I overrule an objection, we keep going in the direction we were going. If I sustain an objection, then that lawyer needs to head in a slightly different direction. Every once in a while, an objection comes a little bit after a witness started answering because the question seemed like it was an okay question, but maybe the answer went in an unexpected direction. And a lawyer may say, objection, move to strike. I may tell you at some point during the trial to disregard the testimony you just heard. And I'll be clear about it because it may be that the witness got 4 sentences out before there's an objection. And it was the sentence about, that's when I saw the car run the red light. And for whatever reason, that witness shouldn't have been permitted to say that. I'll tell you to disregard what the witness just said about the car. And you need to follow my instruction. If you wrote it down, cross it out. If you're back in deliberations and one of your colleagues says, hey, remember that witness said he saw the car run the red light, and you remember I told you to disregard it, you need to police that and say, the judge said we need to disregard it. I don't want you to panic. It's not going to be the kind of thing where the entire case hinges on that one thing that you heard, but you need to not have heard anymore. But if I tell you to disregard something, it's important that you do so. So lawyers may object, perfectly appropriate for them to do so. Every once in a while, and it happens much less often, a lawyer may stand and say, Judge, I have a motion. Motion is code for you probably have to go back to 8E because there's something that we need to talk about outside your presence. The lawyers need to be able to speak pretty freely about what their concern is. And if they speak freely, you may hear some things that they're trying to keep out. We try to handle those motions before you get here or after you leave. It's what we were working on while you were sitting over in 8E. And ideally, we would have started that before 1, but I had drug court. So normally we try to make you not sit around for it. But sometimes things come up that we have to deal with then and there. And if it's involved enough, we'll ask you to take a break. And I ask you, please, to bear with us while we do that. Now, I have to rule on the motions. I have to rule on the objections. Nothing I say in making those rulings, nothing I'm saying now, nothing I said during voir dire is evidence in this case. My role in this case is solely to see that it is fairly tried according to Georgia's laws and the rules of evidence. And so you should never interpret any ruling I make. If I sustain an objection, if I overrule an objection, that I'm favoring one side or the other. I think someone is doing a better job. If I sustain an objection, that simply means I've concluded that that's a valid objection and the rules of evidence preclude whatever was about to happen. That's it. I'm not making a comment on how the case is going or anything like that. I remain neutral in this case, and I just want to make sure that it's a fairly trial. Your job is to decide what the facts are in this case and figure out what the resolution should be. This is a case that the parties were not able to resolve, and they need your help doing so. You're going to do that based on the evidence, the testimony, and the physical exhibits. In performing your job as fact finder, you must determine the credibility or believability of all the witnesses you hear from. You will decide which witnesses you believe and which you don't believe, if there are any that you find to be not credible. It may be that you find everyone to be completely credible. That happens. There's nothing wrong with that. But you will be assessing credibility or believability with every witness. And in determining that, you are free to consider everything you know about the case and that you've heard up to the time of that witness's testimony, the manner in which the witness testifies, his or her apparent intelligence, the witness's apparent interest in the outcome of the case, or any potential bias that may be highlighted for you that you find the witness may have. I have no idea what that was. We're still good? All right. No one was shocked. All right. You are free to believe or disbelieve all or any part or none of witness testimony. You determine what is worthy of belief and what is not. While you are determining the facts of this case, you may determine that there are conflicts in the evidence, that some things don't quite add up. If you do find conflicts in the evidence, you should try to reconcile these conflicts as if every witness was testifying truthfully. As you know, very often two people will recall things differently. They saw the very same accident, and one person swore the light was yellow, and the other person really thought the light was red. And that may be their belief of what happened, but that evidence conflicts. Your difficult job is reconciling those conflicts. If you find that some parts of the evidence are in such conflict with other parts as to make it impossible for you to reconcile those conflicts, it wasn't just a different physical perspective someone had on the situation, then you must believe the evidence that seems most reasonable, probable, and truthful to you. During the trial, you will be permitted to submit questions to each witness. The way that works is not that you raise your hand and say, hey, I'm going to ask this witness a question now. And certainly don't ever shout anything out. But when a witness is done with examination, both sides have had a chance to ask the witness questions. I will ask you all to write down, and you should have, and if you don't, let me know, we'll get them to you. You should have in your bag a stack of note cards. Can I get one confirmation that there are note cards in there? No note cards? Okay. Before witnesses start testifying, and we've got time, we're going to get note cards for all of you. This is how you submit questions. So when John Doe is testifying, you're going to be making some notes. When he's done testifying, I'll ask you all if you have any questions. And you can imagine Jeopardy music playing, and you'll write down on one side of a note card your question. If you've got more questions than fit on one side, use another note card. But it's real helpful if you write on only one side. Don't identify yourself on the card by putting your juror number or your name. Just put down your question. What color was the car? That's your question. That's what you write on this card. Deputy will collect all those cards. I will meet with the lawyers, because just like lawyers can ask objectionable questions, jurors can too. And you should draw no conclusions or inferences from the fact that some of your questions are asked and some of them are not, because questions are never evidence. What the lawyers say is not evidence. Your questions are not evidence. It's the answers, the witness testimony, that is evidence. So if you've got questions, you'll get a chance to write them down at the end of a witness's testimony. They'll come to me. I'll confer with the lawyers. Proper questions I will ask to the witnesses. What color was the car? It was green. The lawyers will get a chance to follow up, because very often jurors have very insightful questions that lead the lawyers to have more questions. And so we'll get one chance to follow up with the witness, and then we'll move on. You must decide this case solely on the evidence you receive in this courtroom, the testimony and the exhibits. This principle of law has a very important corollary: no outside research. In this day and age, it is oh so easy to get on a Google and type in Verbena Street. You've heard that address. Do not do that. If it is important for you to see what Verbena Street looks like, these lawyers will make it happen, or you will do your own Google. You will write the question down on this note card. And if it is relevant and proper for you all to see what Verbena Street looks like, we'll figure out a way to make it happen. But you should not conduct any outside research. Obviously, you don't do that directly because of what I'm telling you. Don't go online and research something. Don't do it in a way that might be inadvertent, where you go home and you're talking with family members, or you're online with friends, like, I'm involved in this civil trial and it's about some apartment complex on Verbena Street. A very well-meaning friend will say, Verbena Street, oh my gosh, do you know? And then you're going to start receiving something that may or may not have anything to do with this case from an outside source, that Mr. Kendall doesn't have a chance to cross-examine, Ms. O'Neill doesn't have a chance to cross-examine, and that's entirely inappropriate. The evidence you're limited to is what's presented here in court. And it's only fair, because then both sides have a chance to try to flesh that evidence out and rebut it if they think it's not the right evidence. But if you're online Googling whatever you're Googling, there's no one there to offer you a counterpoint. So please don't do that. If it comes to light that that happened, we may have to do this case all over again. I can promise you one thing: if we have to do this all over again, you will be watching us do it. You will be in here in court watching the entire trial, not as a juror, as a spectator, and you don't get a comfy cushion. So please don't do that. That means that you're going to be kind of boring to your family and your friends and your coworkers, because they're going to say, whoa, what are you doing? And your answer is, I'm in court. It's a trial. What's it about? I'll tell you later. And when this trial is over, you can tell them everything you want to tell them. You could write a book about this case. You could write a song about this case. I don't know if we got any of the bakers. You could bake a cake about this case once it's over. But during the trial, you need to not talk to other people about what you're hearing and what you're learning. If you've got questions, you can scratch the itch by writing them down on your note cards that you don't have yet, but we'll get them to you. That's it from me. I appreciate your attention and your time. I'm about to put my mask on to join you in the public safety. And I'm going to ask Ms. O'Neill. Before I ask Ms. O'Neill, can you make sure we get note cards? If we just get them to Sarge, he can hand some out to everyone. And just get them a big stack. That would be great. Thank you. All right. Ms. O'Neill, are you ready?
I am.
I think we all are.
Good afternoon. I want to start out by thanking everybody.
I'm going to interrupt you, and I promise I won't do it again unless you're breaking the law. Can you jurors tell me, does that big screen just show the screen sharing now? Is it mostly black? Good. I just want to make sure that when you all are presenting, the jurors can see what you're presenting. I can't see it from here.
No, I
All right.
appreciate that. Thank you,
All
Your
right.
Honor.
Sorry to disrupt your rhythm.
That's all right. He's the second most important person in the courtroom. The most important person is always the bailiff, because the bailiff is the guy with the gun. But I want to start out by thanking you, because I know that when you all got on the Zoom yesterday, you were thinking, please don't let me be a juror. Please don't let me be a juror. You had something else planned for this week. But jury service is important. It's the way that we resolve disputes. And without your participation, we couldn't resolve the dispute that we're here about today. And it's an important dispute. It's my client's day in court. And as the judge said, this, and as you figured out, this is not like TV. There's going to be a whole bunch of boring bits. The lighting isn't as good as TV. They're not going to do lovely close-ups on TV. And all the stuff that happens in the commercial breaks, you're probably going to have to sit through and listen. But it's important, and all the parts of the trial are important. And so I really appreciate you giving your time and attention so that we can resolve this matter. So the first thing I want to do is introduce my clients. We have Sarah Tucker, my partner, and I have the honor and privilege to represent John and Brian Dalton. John is the one in the black mask and Brian is the one in the other black mask. And together, they have a company called D2 Property Group, and we also represent that client. I also have some people who are going to help me, because the first person I have here to help me is John Daxon, because let's face it, we're going to have tech problems. You're all here and that's great, but we had some tech problems yesterday with the Zoom, and I can guarantee you we're going to have some tech problems in this trial. Dak's job is to step in and make those problems as short and uneventful as possible. And I've also got Matt Droppelman helping me, because as you can see, I don't know if you can see over here, a whole bunch of binders. You can see a bunch of boxes. Those are the documents that relate to this case. There are a lot of documents, and I'm going to lose track of them. And eventually, at the end of the case, all the documents that are admitted, you're going to get to take back in the jury room with you. Matt's going to help me make sure we can do that effectively and efficiently, that we can get you documents, get documents admitted into the record in an effective and efficient way so that we don't waste time. So my role here today, as the judge said, is to give you a preview of what the evidence in this case is going to be, what you're going to hear, and what you're going to see as you sit as jurors in this trial. And at one level, this case is about a real estate deal involving what we call the Verbena Street properties. This is a development that is over by Anderson Park and Westlake off of I-20. And it consists of several empty apartment buildings plus a strip mall. In the past, it's been operated as a development called Hidden Villages. But in 2016, it was vacant. The buildings were empty, and in fact, some of them had been damaged. This property, we call it the Verbena Street property, or the Verbena Street apartments for short. But you're going to see evidence in this case and hear about evidence that shows that there are many different parcels here. And this property and the parcels contained within it are at the center of the dispute in this case. But this case is not just some boring case over a fight about real estate. This is a case about promises that were not kept. It's a case about money that was taken but never earned. It's a case about the betrayal of trust. It's a case about threats and deception, and ultimately about fraud. And the events that you're going to hear about occurred over a relatively short period of time, about 3.5 years. But the damage done by this conduct has gone on much, much longer, and you're going to hear about that. So you're going to hear that the evidence shows that it was Mr. Hyder and Bristol Consulting Group who made those promises that they did not keep. And you're going to hear that the money that was never earned but was taken by Mr. Hyder and Bristol Consulting Group and American Business Group. Bristol Consulting and American Business Group, you're going to hear, are two companies that are owned and operated by Mr. Hyder. And you're going to hear that the person who betrayed my client's trust was Mr. Hyder. And you're going to hear that the person who made threats to my client was Mr. Hyder. And you're going to hear the person who deceived my client was Mr. Hyder, and was Bristol Consulting, and was American Business Group. And you're going to hear evidence and see evidence, which I believe will show you ultimately that Mr. Hyder and Bristol Consulting Group defrauded my clients. You're going to hear, I expect, Mr. Hyder deny all these things. I expect that when it's his turn to put on the evidence, he's going to get on the stand and he's going to tell you this is all wrong. That he didn't break any promises. That he didn't keep any money he hadn't earned. That he didn't deliberately betray my client's trust. That he didn't threaten them. He may even tell you that he's the victim here and he's the one who lost out. And as the judge said, you're going to have to decide. You're going to have to listen to all of the evidence and you're going to have to make the decision about what does the preponderance of the evidence tell you. And there is going to be a lot of evidence. I expect there's going to be dozens of exhibits and hours of testimony. And I can't preview all of that for you, but I want to kind of give you a roadmap or a picture of how I believe the evidence is going to come in. You're going to hear that this all started in the spring of 2015, when John Dalton first met Mr. Hyder. At the time John met Mr. Hyder, John and Brian were considering getting into the business of investing in residential real estate here in Atlanta. You're going to hear that John and Brian aren't just brothers, like, okay, we have the same parents, but they were close. They both work in the medical field. John is an orthopedic surgeon, and Brian works in medical sales and goes into search operating rooms to show doctors how to use things properly, like hip replacements and knee replacements. 2015, they both had young families. They have children who are close in age. They spent a lot of time together. And they decided maybe what they would do is enter business together as well. And you're going to hear that when John met Mr. Hyder in the spring of 2015, Mr. Hyder held himself out to them as somebody who was knowledgeable about the opportunities for investing in residential real estate in low-income areas in Atlanta. Mr. Hyder told John that this was Mr. Hyder's full-time job. This is what he did for a living. And he knew this industry and he could help the Daltons get started in. First thing that happened is Mr. Hyder offered to sell the Daltons some properties that he had, and then to act as a manager on those properties, find tenants, collect rents, deal with property issues. You're going to hear that from early spring 2015 up to about April of 2016, Mr. Hyder offered to find other houses for the Daltons to purchase. And that when they did that, he would hire people to rehab those houses. He'd oversee the rehabs, he'd get tenants in there, he'd collect the rents. And so a business relationship was formed. You're going to hear that between that first meeting in the spring of 2015 and April 2016, April 1st, 2016, the Daltons purchased 7 rental properties in metropolitan Atlanta, either from Mr. Hyder or through his recommendations. They're all single-family homes or duplexes. They were all purchased by my clients, the Daltons and D2, and they're still owned by them today. You're going to hear that during that first year, spring of 2015 to about April of 2016, things were good. Mr. Hyder kept all the promises he made to the Daltons during that time period. He helped them find financing when they needed it to buy these properties. He collected and turned over all the rents. If there was a problem at a property, he handled it. As the Daltons bought more and more properties and expanded their portfolio, their work with Mr. Hyder expanded. His company, American Business Group, was the property manager for all these. You'll see that American Business Group that first year handled all the problems, got all of the rents collected, and you'll see that in that first year, the Daltons learned to trust Mr. Hyder. Mr. Hyder built that trust, and the Daltons believed that they were working together in this partnership where they could rely on Mr. Hyder. You're going to hear that things changed in May of 2016. You're going to hear that in May of 2016, Mr. Hyder presented John Dalton with an idea that they could invest in the development of the Verbena Street property. You're going to hear that the Verbena Street property in 2016 was owned by Abe and Denise Vaknin through some LLCs that they owned. Mr. Vaknin is going to come and testify in this trial. He's going to testify remotely because he's in New Jersey. But he's going to come and testify about how at the end of April 2016, Mr. Hyder came to Mr. Vaknin's home in New Jersey and offered to buy the Verbena Street property. Mr. Vaknin is going to tell you that standing in his home that day, Mr. Hyder wrote out an offer to purchase, and that it was signed by Mr. Hyder and Mr. Vaknin that day. Mr. Vaknin is going to come and he's going to tell you about what led to that contract, about what he agreed to sell, and what he agreed the terms were going to be, and what Mr. Hyder agreed to buy. And you're going to get to see that offer to purchase. It's going to be one of the pieces of evidence in this case. But Mr. Vaknin is also going to tell you that Mr. Hyder didn't keep all the promises that he made to him in his living room that day. He's going to tell you, Mr. Vaknin is going to tell you that some of the promises he found out were broken fairly quickly, within a few weeks after this document was signed. Some of them took longer for Mr. Vaknin to find out, in fact, had been broken. But you're going to hear that the promises made to Mr. Vaknin through this document and in conjunction with its execution weren't the only ones that Mr. Hyder failed to keep. You're also going to hear from the Daltons about the things that Mr. Hyder told them about the Verbena Street properties, the promises he made about those properties that weren't kept. John Dalton's going to come and tell you about that. Now, John's going to admit to you that he didn't vet everything Mr. Hyder was telling him in 2016 about the Verbena Street properties as carefully as he might have. He relied upon that business relationship and the trust that had been built up in that whole year before. And he took Mr. Hyder's word for some things that, in hindsight, he feels like he shouldn't. He's going to get on the stand and he's going to admit that to you. But he's going to tell you that in the spring of 2016, when things were good and Mr. Hyder suggested that the Daltons invest in the Verbena Street property, that they buy this property, they renovate the buildings, they get everything rented out, that John was interested. He's going to tell you that he went out to the site and he met with Mr. Hyder that day and they looked at the properties. He's going to tell you what Mr. Hyder said to him when they were out there standing actually at the site. He's going to tell you what Mr. Hyder told him the plan should be to purchase this, what should be purchased, what should be invested in. you're going to hear that while they were standing out there that very first day, Mr. Hyder showed John an appraisal that Mr. Hyder said showed the potential to make more than $10 million if they bought and rehabbed these properties, then rented them all the way out, and then resold the property, or maybe even kept it as an operating development. And you're going to get to see that document. You're going to get to see that appraisal. Now you can see that this appraisal says it was done for Atlanta Beverly LLC. That's one of the companies owned by Mr. Vaknin and his wife. But wait till you hear what Mr. Vaknin has to say about this report. In this report, you're going to see some legal descriptions of the properties, parcels A through I. And I know that's kind of hard to read. You're going to get this document into evidence and be able to look at it, and you're going to see these descriptions throughout this trial. These property descriptions, A through I, describe the apartments and the strip mall on Verbena Street. And the property descriptions are important to this case, and you're going to see them in a lot of documents, and you're going to hear a lot of testimony about them. Two of the ones that you're going to hear a lot about are for parcels E and F, which are on pages 8 and 9 of that particular document there that we have on the screen. And they're of particular importance in this trial. You're going to see these descriptions for parcels E and F again and again, and you're going to hear about them in testimony, and then I'm going to talk about them again at the end of the case. John's going to tell you when he gets on the stand that originally the Daltons were reluctant to invest in this deal. It's a big investment. He's going to tell you that ultimately they did agree to do the deal, and he's going to tell you why. He's going to tell you that they agreed to do it because Mr. Hyder promised them that he could get financing to buy and rehabilitate the property. Mr. Dalton's going to tell you that Mr. Hyder promised them he had experience in these things. He could get the money. He could oversee the rehab. If they decided to keep the properties, he could manage the properties. All my clients had to do was agree to take the opportunity and get the loans. And so the Daltons agreed that they would give $150,000 down for this opportunity, $100,000 of which was supposed to be returned if the deal didn't go through. You're going to see that there's a contract about that, a standard offer to purchase and sales contract. Mr. Dalton's going to tell you that he signed this contract, that is his signature right there at the bottom, providing for the opportunity to purchase the property, which he believed to be all of the parcels, residential and retail, and that Mr. Hyder's job would be to find the financing both for the purchase and the rehab. But you're going to hear that this is not the only version of the standard offer to purchase and sales contract that existed. You're going to hear that there's another version that Mr. Hyder made. And there's differences. They both do say that the $100,000 shall be returned if the deal is not closed by June 30, 2016. But the second version also says the purchaser to acquire 100% of the shares of the LLC. And the second version also has a signature for the seller, which didn't exist in the document that John Dalton signed. Mr. Vaknin is going to come in and he's going to tell you that's not his signature. And he didn't sign this document and didn't agree to these terms. Now, John's going to tell you that Mr. Hyder did not get financing by June 30, 2016. This is one of the facts everybody agrees on. Mr. Hyder did not get financing by the June 30th deadline in these documents. You will hear that during June 2016, Mr. Hyder did connect D2 and the Daltons with a potential lender called the Vittorio Group. It's also called the Chevalier Group. And you're going to see that there was a contract entered into to see about getting financing from that. That contract required $230,000 to be placed in escrow during a due diligence period with a 100% financing guarantee if the deal didn't go through within 3 months. You're going to hear that the Daltons didn't have $230,000 for this, so they borrowed it. And they put the money in the escrow account that they were told to do, believing that this was part of the deal. This was part of the process. And they were going to end up getting the money that Mr. Hyder had promised them to purchase and rehab those properties. But you're going to hear that the Vittorio Group, the Chevalier Group, they did not provide financing within 3 months or ever. You're going to hear that the money was not kept in escrow, that it had been taken out, and that the Daltons were forced to hire a lawyer to try to get that money back. A lawyer that Mr. Hyder recommended to them that the Daltons paid. And you're going to hear that some, but not all, of that money got recovered. But wait till you hear whose bank account it went into and why. Now, you're going to hear from John Dalton that he, not Mr. Hyder, not Bristol Consulting, ultimately secured a loan to buy the Verbena Street properties. He's going to tell you how he borrowed that money from Fowler Financial. Fowler Financial is a company that is operated by Mr. Dalton's friend, Dr. Robin Fowler. And John's going to get on the stand. He's going to tell you that he went to his friend and he got this short-term loan for more than enough money to buy the property so that there could be some money to pay for carry costs during the period between purchase and when Mr. Hyder would make good on those promises about finding permanent financing. And you're going to hear that the closing for that loan from Financial Fowler and my client's purchase of the Verbena Street properties was done by another attorney selected by Mr. Hyder, Crystal Kimbrough. The Daltons will tell you that they went to Ms. Kimbrough's office on July 13th for the closing, July 13th, 2016, and they signed the papers that she gave them about the closing, but that things did not ultimately go as the Daltons had expected when they walked out of that closing. You're going to hear from John Dalton and also from Mr. Vaknin that what happened at the closing doesn't match up to what either of them thought the deal was. You're going to see that there were documents given to the sellers, the Vaknins, that were different than the documents given to the buyers, the Daltons. You're going to see emails that send one set of documents over here and a different terms set of documents over here. You're going to hear testimony, and it's going to be disputed, but you're going to hear testimony that Mr. Hyder was telling the sellers one set of terms and telling the buyers a different set of terms. And specifically, what you're going to hear is that when Mr. Hyder couldn't close the deal by June 30th, as promised, Mr. Vaknin wanted to raise the price. He wanted more money. And that you're going to hear Mr. Vaknin tell you that Mr. Hyder agreed to pay that more money. But you're going to hear that he didn't tell that to Mr. Dalton. John's going to tell you that what Mr. Hyder told him was a different story. What Mr. Hyder told the Daltons was that Mr. Vaknin was trying to jack up the price to cover the back taxes on the Verbena Street properties that John's deal said the seller was supposed to pay. You're going to see that what Mr. Hyder told the Daltons was, we got to sue the Vaknins in order to get that money back. So they had to hire yet another lawyer recommended by Mr. Hyder that the Daltons had to pay for that lawsuit. But these were not, unfortunately, the only things about the deal that weren't as they were represented to be. You're going to see that among the documents that were done at this closing are documents that show my clients, D2 Daltons, are getting all of the parcels, A through I. And you're going to see that this wasn't in just one document. It's in a whole bunch of documents. And you're going to see that those legal descriptions for parcels A through I are on the limited warranty deed that was filed here in Fulton County Courthouse, transferring property to D2 Property Group. And it has, you'll get to see this, the legal descriptions for parcels A through I. But you're going to hear that one of the documents that was not shown to the Daltons when they went to the attorney's office and did that closing was not shown to the Daltons, in fact, at any time until much, much later when everything had fallen apart, is that there was another warranty deed that had been executed, which transferred property to Bristol Consulting, property my clients paid for. And you're going to see that those two tracks described on this warranty deed, transferring property to Bristol Consulting, are the exact same legal descriptions as parcels E and F on all the documents shown to my clients. And you're going to see evidence which shows that although these two deeds were recorded at the same day, at about the same time, the one with the transfer to Bristol Consulting was filed just a little bit earlier, so that it's got the priority position on the property. You're going to hear that at the closing, where my clients borrowed the money from Fowler Financial to pay for this property, Mr. Hyder and Bristol were given control over more than $450,000 of that loan money that was supposed to be used to pay for carry costs on the property that would be incurred during the time period between the closing of the loan from Fowler Financial and the replacement financing that Mr. Hyder and Bristol were promising to get. You're going to hear in some detail about how Mr. Hyder failed to hold up his end of this agreement. You're going to hear that he never got any financing to pay off that short-term loan from Fowler Financial. He never got any financing to fund rehabilitation of this property. And ultimately, he didn't use that more than $450,000 for carry costs. You're going to hear use some of it right at the beginning, right after that July date, when he got and was control of the money, he used some of it right then. But you're going to hear that when it became clear he wasn't going to get any replacement financing by the time the Fowler Financial note came due, he stopped using that $450,000 as carry costs and started telling my clients they had to pay them. You're going to hear that because Mr. Hyder didn't get any replacement permanent financing to pay off that Fowler Financial loan that was due in September of 2016, Mr. Dalton went to Robin Fowler and he got the due date extended. And you're going to hear that he got it extended a couple times, first later in 2016 and then into 2017, all for the purpose of allowing Mr. Hyder the opportunity to get that permanent funding that he had promised he would get. And you're going to hear that each of those extensions cost my clients money, that there are fees associated with each of those extensions. And my clients had to pay it. Mr. Hyder wouldn't use the money from the $450,000. It was coming out of my client's pocket. And you're going to hear that as 2016 wore on and became 2017, and no new financing was secured, Mr. Hyder stopped using that extra money from closing for anything related to Verbena. You're going to hear testimony and see proof that the Daltons had to pay and pay and pay and pay and pay. They had to pay for surveys and lead and asbestos tests and lawyers' fees and more lawyers' fees and more lawyers' fees and fees for prospective lenders and fees for insurance, more and more and more and more and more and more, all through the end of 2016 into 2017. And you're going to hear that that insurance that my clients ended up having to pay the premiums on turned out to be important, because in 2017, one of those vacant apartment buildings at the Verbena Street property caught on fire. And so they had to make a claim under their insurance policy for that. And you're going to see that that claim was paid. More than $330,000 was paid by the insurance company whose premiums my clients had paid. More than $330,000 was paid in damages on that fire by the insurance company. Wait until you hear whose bank account that went into and why. And you're going to hear that despite all of the money that the Daltons put into this project, all of their efforts, all of the extensions that they were able to get from Fowler Financial, ultimately, because no permanent financing was ever obtained, they lost the property, and in the fall of 2018, Fowler Financial foreclosed. And you're going to hear that even then, after it's foreclosed, Mr. Hyder refused to let go of the chance to make money on this property. You're going to hear that first he told my clients they had to file bankruptcy. D2 had to file bankruptcy, and they had to file personal bankruptcy in order to stop this foreclosure. When that didn't work, he told them they had to sue somebody, sue Fowler Financial, sue their lawyer, sue somebody to stop this foreclosure. And when that didn't work, he threatened to sue the Daltons for $1 million if they didn't figure something out. You're going to hear that at the end of 2017, Mr. Hyder called John Dalton, and he said he felt that he, Mr. Hyder, had gotten the short end of the stick here in this deal. And that he really felt that to make it right, my clients had to pay him $100,000. And if they paid him $100,000 by the end of 2017, then he wouldn't sue him for this $1 million he believed they owed him. Mr. Dalton's going to get on that stand. He's going to tell you he paid that money. And he's going to tell you why. And you're going to hear that that is actually the last of the promises Mr. Hyder made to my clients that were broken. Because 3 days after that very last part of the $100,000 was paid, he sent my clients a notice of default, demanding that they pay him $1 million. And you're going to hear that Mr. Hyder did, in fact, sue my clients. And so my clients countersued. You're going to hear that Mr. Hyder's claims against my clients were dismissed. And we're here today on what's left, my clients' claims against Mr. Hyder and Bristol and ABG. This is a case not just about a boring real estate deal, but about promises made but not kept, about money taken but not earned, about betrayal of trust, about threats, about deception, and ultimately about fraud. And at the end of this case, I'm going to ask you to find Mr. Hyder and American Business Group and Bristol Consulting liable to my client for those things. And I'm going to ask you to award money to my client, not just for their out-of-pocket losses, which are considerable, but for other damages, for the stress they've had to endure and the toll that this has taken on them and other damages. So I appreciate you paying attention today. I look forward to trying the case with you, and I'll get to talk to you again at the end of the case.
Thank you, Ms. O'Neill. Mr. Kendall, do you want to give an opening now or are you going to reserve?
I'm gonna give it now.
Great, then now's the time.
Good afternoon, everyone. I'm Wayne Kendall. I have the pleasure and the honor of representing Mr. Donnie Hyder. I want to introduce the folks over here to my right, your left. My paralegal, Ms. McGuinn, Linnell McGuinn, will be helping me out with some of these documents. And Mr. Hyder and Ms. Selma Hyder. Ms. Hyder is a part owner of one of these companies that Mr. Hyder owns. And you've heard about Mr. Hyder, and I've introduced him on yesterday. Well, back some time ago, there was a famous radio commentator by the name of Paul Harvey. Some of you may be old enough to remember Paul Harvey. Paul Harvey was famous for saying, and now the rest of the story. So I'm going to play Paul Harvey today and give you the rest of the story. Ms. O'Neill basically gave you a bare bones indication of what happened in this situation over the course of a number of years that these parties worked together. And she quite honestly told you the truth, partially. She told you that Mr. Hyder entered into a business relationship with the Daltons, John Dalton, his brother Brian Dalton, through their company, D2 Property Group LLC. And that the purpose of that business relationship was to buy properties in low-income neighborhoods on the south side of Atlanta that they wanted to invest in for purposes of what? Making a profit. So they needed an individual like Mr. Hyder, who knew his way around the neighborhood, who could identify these particular properties that were good investment deals for them. Now, Mr. Hyder was engaged in the business of buying and selling real estate. Some people would call it flipping properties. That is, buying properties low, undervalued properties, making some improvements in those properties, and then almost immediately transferring those properties to someone else at a higher retail sales price. That was his business. Brian and his brother, John and his brother Brian, found that out, knew that, and decided that this was a good person to associate with for purposes of making a profit on investing in, as Ms. O'Neill accurately told you, low-income residential properties on the south side of Atlanta. That relationship went swimmingly for a couple of years. Mr. Hyder identified the properties. The Daltons provided the money to purchase the properties. Mr. Hyder found tenants for the properties. Mr. Hyder gave them monthly reports concerning the renovations to the property, the amounts of money that he spent to renovate the properties, and the collection of the rents. Everything went fine, reports were submitted, everybody's happy. And as Ms. O'Neill accurately told you, the Daltons developed a certain amount of trust in Mr. Hyder. All the way through the early spring of 2016, because Mr. Hyder had helped them to find financing for these properties. He introduced them to financiers. He introduced them to banks. He handled any problems that came up. He was the property manager. And as she told you, he turned over all of the rents. There was no problem. Well, in May of 2016, these parties decided that they were going to invest in that Verbena Street property. There was over 100 abandoned, dilapidated apartment units. Some of them had been burned out. There was asbestos. There were people living in the apartments. There were drug deals going down. There was all kind of problems with this property. and it had been vacant for over a decade. This was a major undertaking, a major real estate undertaking, much more advanced, much more requiring of skilled financial and development expertise than buying and flipping single-family residential houses that you're just gonna go out and rent out to some individuals and collect the rent. Totally different ball of wax, completely. Completely over the head of the Daltons, and certainly gonna be a challenge for my client. Well, Mr. Hyder, the evidence is gonna show this, flew up to New Jersey to talk to the absentee landlord who lived up in New Jersey, who owned these abandoned, dilapidated, drug-infested, burnt-out apartments that had been vacant in Southwest Atlanta for over a decade. And he and Mr. Vaknin and his wife, Denise Vaknin, agreed and signed that offer of purchase that you saw up there. You're gonna see that again. They agreed to sell that abandoned, dilapidated property, including a shopping center, a strip shopping center that was across the street, for the sum of $1.2 million. And that deal was to go down in 60 days. And Mr. Hyder paid Mr. Vaknin there in his living room the sum of $5,000 as an earnest money deposit on that transaction. Mr. Hyder having the signature in hand. Now, this was a contract, or you saw it, it's a handwritten offer to purchase, which Mr. Hyder later reduced to a standard form offer and purchase contract. Now, Mr. Hyder is not a lawyer. He's a real estate person. Mr. Hyder does not have a law degree. In fact, Mr. Hyder has never even been to college. Mr. Hyder is a guy that's out here buying residential properties, fixing them up, and selling them to anyone who is willing to buy them. So he does his best to put together this offer and purchase agreement, which he then goes to the Daltons, who he's already been in business with for the last year or so, year and a half, buying these properties. They're happy, he's happy. He's turning over the money. He's giving them reports. He's helping them to get financing on the properties. Everything's going great, guns. Nobody's got any problems. Hey, Donnie, you're the greatest in the world. We got these properties. We happy with them. They're churning money. They're cash flowing. We good to go. Then he steps up to this Verbena Street property, which is, by everybody's estimation, a real challenge. He agrees in a document, as he said, you're going to find out that their signature is on this document, says that his company, Bristol, will sell these burnout, dilapidated, drug-infested apartments to them for the sum of what? Not 1.2 million, but $3 million. They signed the deal. They said, okay, Donnie, that's great. We're going to make tons of money. We're going to renovate these apartments, and we're going to sell these apartments for whatever number, $10 million, whatever it was. And they go out to the property, like Ms. O'Neill said. And he says to John Dalton, John, I'm going to keep this strip center over here that's basically vacant as well. And you're going to take all of these apartments, 100 and some odd unit apartment complex. And I may be wrong on the number, we'll get that straight. But you're going to take the apartment complex, and I'm going to use my best efforts to help you to finance these projects. And at the end of the day, you're going to be able to sell these properties for a profit, just like we were doing all the time with these residential properties. Now, she put 7 properties up there, but I believe the accurate number is 8. But we'll get that straight as well. So they entered into this agreement. Mr. Hyder uses his best efforts to go out and seek financing, not on single family residential properties at this point, but this huge burnt out, dilapidated, drug infested, burnt out. I mean, it's in terrible condition. And he goes to the bank, he introduces them to some financiers. He goes to the bank. You're going to hear from one of them. We're going to bring in here to talk to Mr. Dalton about this project. And he's trying to get the financing. Well, the 60 days runs out. Well, as she said, Mr. Wagner wants more money because 60 days ran out. Well, ultimately it was agreed that he's going to go forward with the deal. The Wagners, the Daltons then go to a friend of theirs, another doctor, a doctor friend. His name is Robin Fowler. Mr. Fowler has a company called Fowler Financial. Fowler Financial puts up $2 million on the $3 million purchase price. The other $1 million is represented by a promissory note from D2 to Mr. Hyder's company that's guaranteed by the 2 Dalton brothers. They close the transaction. The transaction is closed by an attorney whose name is Crystal Kimbrough. Now, you're going to hear them say, and the evidence that they're going to try to put in this case is going to be that Crystal Kimbrough was incompetent, committed legal malpractice, and did not do the things that she was supposed to have done in order to close this transaction correctly. She's going to testify. And she's going to testify that all of that is inaccurate and not truthful. And she did what she was supposed to do according to the documents that she was working with at the time to perform this closing. You're going to hear that that Mr. Wagner misrepresented some of the debts that were owed on this property. And you're going to hear that as a result of that misrepresentation of the debts that got taken out of the closing because he owed taxes on the property that he had previously indicated he did not owe, that the Daltons, and that through their company D2, sued Mr. Wagner with the help of Mr. Hyder. So what you had was Mr. Hyder, the Daltons, and D2, their company, suing Mr. Wagner and his wife for fraud, for misrepresentation concerning the taxes. So the 2 parties that are diametrically opposed in this case were on the same side against the Wagners. And there was a lawsuit. And that lawsuit was about to be tried when the Daltons went to the Wagners and said, hey, you pay us some money. You pay us, that is just the Daltons, not Mr. Hyder's company. You pay us some money and we will agree to testify against you against Donnie Hyder. And you will agree to come into our case and testify against Mr. Hyder. And here's that agreement between the Daltons and the Wagners. And they're going to call Mr. Wagner in here to testify against Mr. Hyder pursuant to this agreement where they agreed to cut his losses and let him pay them some money that was less than what they were asking for in return for him coming in here to testify against Donnie Hyder. So when he's up here testifying, or he's on the screen testifying because we allowed him to testify remotely, remember that he cut a deal for that testimony, that they cut a deal for that testimony.
Objection, Your Honor, that's recommended.
Yeah, let's stay focused on what you think the evidence will show without spinning it.
All right. Let's get back to Crystal Kimbrough. We're going to also learn that the Daltons sued Crystal Kimbrough. See, the evidence is going to show, and you're going to be able to surmise this on your own. And what I'm about to say is going to sound a little bit harsh, but I don't mean to be too pejorative because this is what the evidence is going to show. The evidence is going to show that Mr. Dalton is going to take the stand. And what Mr. Dalton is going to say from that stand is going to contradict about 50% of what Ms. O'Neill has told you is going to come into this case. And Mr. Dalton, Ms. O'Neill told you, and as the judge has previously indicated, nothing we say or the court says is evidence in this case. My purpose here is to kind of give you a preview of what I expect the evidence to show. And what I expect the evidence to show is that Mr. Dalton is going to take the stand. And what he's going to say is going to be far, far, far from the truth. What he's going to say partially is going to contradict what Ms. O'Neill said. And the reason I say that is because we have taken Mr. John Dalton's deposition. And the things he said in that deposition, which we're going to bring to your attention and we're going to show you as evidence from his previous testimony, is going to contradict many of the things Ms. O'Neill said. Number one is going to be that plaza was never, ever, ever a part of the real estate transaction that Mr. Hyder was selling to the Daltons. And Mr. Dalton is going to testify, I think, potentially falsely, which we're going to correct by his previous deposition testimony, as the evidence will show through his previous testimony, that he knew that that plaza was never, ever a part of this transaction because he went there and he and Mr. Hyder had a discussion about it before this transaction ever got written up. Number two thing that I think you're going to hear from Mr. Dalton, pursuant to his previous testimony, is that the deal was $3 million he was due, less the $1.2 million that was due to the Vagnans and all other costs associated with this transaction, to the point where Mr. Hyder was to get the differential. That differential came out to be some $457,000 or so. And that Mr. John Dalton signed off on all of that, agreed to it, and walked away happy. Not only did he walk away happy, but after his buddy, Robin Fowler, said, John, I can't keep extending this $2 million. It's supposed to be a short-term 6-month loan. I've extended it. You need to own up. And then there's another individual, and that's Mr. Sam McGuire. You're going to hear from him because we subpoenaed him. Mr. McGuire, Sam McGuire, is a lawyer. He's a real estate lawyer. He's Robin Fowler's lawyer. And what you're going to hear from Mr. McGuire is that he and John Dalton said, hey, look, let's work this out in a quote unquote friendly foreclosure. There's a text message that you're going to see from Mr. McGuire to Mr. Dalton that Mr. Dalton actually believed this, actually sent it to Donnie Hyder, saying, Donnie, we're going to work this out. Don't worry about it. Robin is going to foreclose. Well, a foreclosure kills his $1 million promissory note. That's a second mortgage on this property. So they said, Mr. McGuire said, and you're going to see this in the evidence, we're going to do a friendly foreclosure. We're going to wipe Dunny out. And then you and I can sell this property and split the profits. Several months, few months after Mr. Fowler, John Dalton's buddy, his friend, his doctor friend, foreclosed on the property on his $2 million note, he sold the property for $3.5 million. He made a $1.5 million profit just months after he foreclosed on the property. But even after that, Mr. McGuire was still sending emails to Mr. Dalton saying, hey, John, we can work this out. You know, we're going to cover some of your losses. We're going to work this whole deal out. And guess what? John Dalton sent those emails to Dunny Height. We'll work it out with you. We'll split the profits 50-50. Don't worry. We're going to make you good. You're good with us. We just needed to do this friendly foreclosure. Do what? Get rid of Dunny Height. Now, friends, that is the rest of the story. And you're going to hear all about this. This is all documented. You see these? These are their documents. Those documents over there in those boxes are their documents. This is not, I would agree, not a boring real estate case. It's filled with intrigue. It's filled with deception. And Miss O'Neill was correct. There's a betrayal of trust, not by my client, by her clients. There's deception. Friendly foreclosure is nothing but deception. When a lawyer sends a person an email saying, hey, guy, we know you owe us this money, we're going to foreclose on you, but it's a quote unquote friendly foreclosure because we need to get rid of this guy. There's a lot of deception. Now, they've sued him for fraud, and we think the evidence is going to show anything but that. They sued him for promissory estoppel. We think the evidence is going to show anything but that. They've sued him for conversion. We think the evidence is going to show anything but that. They've sued him for unjust enrichment. Didn't happen. They are the ones that have sued the Vaglins, settled with them, got paid. Crystal Kimbrough, still in process, and him. And their buddy, the evidence is going to show. Fowler sold that property and made $1.5 million, which they could have made. Had they paid Fowler off his $2 million, they could have sold him for $3.5 million and made at least $500,000 in profit, even if they paid him $1 million. And that was without making any improvements. It was still a dilapidated, burnout, drug-infested, dilapidated property when Fowler sold it for $3.5 million. Now that's the story that you won't hear from them, but you will hear from us. And I thank you for your service. I thank you for your attentiveness. And Mr. Hyder thanks you for your attentiveness. Thank you.
And I thank you too. We are ready for the first witness, but I need to take your pulse. You've been listening for a little while. Are people ready to have that first witness, or does anyone need a break? There's a break. Several hands. That's all it takes. We're going to try our first break. We're going to try to keep it to only 5 minutes, but that'll depend on how quickly you all get organized, but you all need to go. Some of you don't stay in. So everyone's going to follow Deputy Gordon to 8E. Hold on. Okay. Take a seat. You're going to follow Deputy Gordon to 8E. You'll be there for a few minutes. We'll bring you back, and we'll start with plaintiff's first witness. Please don't talk about the case while you're over there. When I mentioned no outside research, it's not appropriate for you to begin your deliberations now. You actually have heard no evidence. You don't know anything about the case from an evidentiary perspective. You have two clearly competing forecasts as to what the evidence will show, but you haven't heard any evidence. Your deliberations don't start till closing arguments. I give you the charge and you've got all the evidence. So talk about anything else under the sun with this case during your short break, and I'll see you in about 5 minutes. Go with the deputy, please. Yes, ma'am. Not on the record. Quick. You can ask your logistical question now because we're not on the record.
Our first witness is going to be Mr. Beckman. So we've got some documents. How does the court want us to do? I show them to him to get authenticated so we can know. How do you want to do that with the display?
So it's a good question. And I think we have the technology to do that. I don't have any binders yet, so I'd love to get some binders before we start doing that. Mr. Kendall, do you have all of plaintiff's binders?
I have 5 binders over here.
Okay,
7.
Oh, 7.
And we have 2 copies for the record.
great. Okay, and so we'll get those to me and Ms. Niles. So what you want to be able to do is show something to Mr. Vaknin, so you would share on your screen. We'd want it to appear on Mr. Kendall's screen and mine, but not the big screen over there.
Right, and
Okay.
they are, with one exception, I think, they're all documents which we agreed are authenticated. I think the only one that's an issue is you objected during Mr. Dalton's deposition to the text message excerpts.
If you want to take,
And I want to show him one of the text messages.
you're welcome to stay out here.
Exhibits. You objected because there's 174 pages of them, and instead of marking 174 pages, I've had like page 52 and 54. And I want to show Mr. Beckman one of those pages, but everything else is,
If Mr., I guess, the short circuit would be if Mr. Kendall does not object to the admissibility of the documents, then we can skip the step of keeping that screen off, but I'm not requiring anyone to stipulate.
If she can show me the document, I want to make this as smoothly and as quickly.
Great. Are those for me? I will not make you hold them. You want to come? Well, I'll grab them. Just reach over. I don't know that I can grab
I'll
both
give you
at
the
once,
numbers.
but
Binder?
got it? I don't want you to fall. You good?
Hold on, let me
We grab it.
top one.
And I'll grab the bottom one. Oh, this is a workout. My goodness. 1 and 2. Thank you so much. And this is 2 of the same thing, or your exhibits span 2? Great, thank you.
We have 7 binders.
Yep.
But they have numbers on them, so we'll be able to say full volume 2.
Okay,
You ready?
Yes.
that's the 7, or that's 1 through 5?
This is 1 through
I
5.
agree. Exhibits.
More real estate.
They're in different ones, so you want to write down the numbers? Okay. That might be easier.
5
I mean,
through
you can
7.
if you want.
Thank you.
We got 7 binders. Exhibit 30.
Wait a minute, wait a minute.
Oh, sorry.
Yeah, go ahead. Don't talk to the jurors.
What was that exhibit?
30. 32. Oh, I got them out of order. 1. 5. 4.
Your Honor, here's an index.
Thank you.
31. 25. 2, 3. I have them out of order.
Oh,
So the 2 binders I got, ma'am, they have the same thing in them.
Oh, give me the wrong one.
I think you're
well, it
missing.
doesn't have 1 through 36 and then 36 through 90.
Nope, I have 2 copies of 1 through 36.
Oh.
So I'll trade you. Everything okay with the jurors? Okay.
Sorry.
No problem. I'm glad I caught it. Whoop, careful. All right.
Yeah.
All right. I got that. You got that? Yep. This goes to 107. This is the other one, part 2. Excellent. Thank you. All right. All right, I'll be back in a couple minutes, then we can check on the jurors and we'll start with Mr. Vaknin. Is Mr. Vaknin on standby?
Yes, it's on standby.
Okay.
Those are all of them. You know what, Wayne? I took the text message out because I figured this would be more efficient.
Bottle of water around.
In the vending machines, there may be bottled water around.
Oh, thank you.
No problem.
I'm gonna do it from here because I don't think the camera's gonna. That's the camera? He can see me standing. Oh, he can't see me standing. God, I love you. Not in an inappropriate way. Please do not record me. Perfect, because I'd rather do it.
All right, I'm gonna.
No, not
I'm trying to respect it.
And I think, is Lindsay Roach maybe?
She's my law clerk.
Okay. All
And
right,
then
she's trying to log in
Philip Lee is my
then.
summer associate.
I've
And
sent
there's
her,
another
Okay, so
guy,
we have to
Brandon
ask them
Hedgepeth.
to let her in, right?
yeah, and I don't see,
And
I
Michael
sent him the
Harper
link
is
and I'm not
Mr.
seeing him jump
Vaknin's
in.
lawyer. Wayne, is it gonna, like, feel like I'm encroaching on, or I can't do that, let's see if I can put that there, but
I'm gonna go to the
I feel like if
restroom.
it's encroaching your space, I can
Yeah.
share here.
No, not really. Where?
So let me know if you're gonna object so that we can just go ahead and display.
All right, let me, okay,
I think these are all ones that we had sorted out before, but
pull up those numbers in their documents.
Well, remember, is this the new set that they sent us yesterday? Where we couldn't get because. there was
Oh, we never did
password?
get that?
We never got. the
none of
password.
these are, and we gave you paper copies of everything.
Okay. But these are electronic, so we should have all these
Yeah, and what I'll
electronic.
do is, those weren't new, they were just replacements. So since you still couldn't open that link, I'll have somebody send you individual PDFs, and multiple
Oh,
emails.
okay.
But you can look at everything in the binders.
Okay.
You said that was their position. Their position.
Do you disagree with 50% of what I just said? No.
Right.
I once had a client, sort of, yeah, it was in a, ma'am, I forgot your last name.
It's my grandmother.
When you get the new link open yesterday.
Yeah, we ended up, as you see in the stuff, we shuffled, and finally just said, just do it straight through. He admitted that he didn't care.
Yeah, not today, that's tomorrow. Right, I know. So I got a tip for you, you go home tonight. You're supposed to lay
Yeah,
on the floor.
look it up on your computer.
Incredibly hard, like you can't get your arms back like that on the floor flat. It's amazing, but
You got your extra batteries, I think it's mine.
but that's how those are written, so it's all- everything in there, you're sitting there. all
They got
stuff
They
like
keep dying,
that.
I think it's.
I don't have any batteries.
You have to remember to put it on.
But you can use, you can use that. But that.
And there's no-
Do I have another?
No, I don't. Dead already. I mean, it keeps dying, I have to keep turning it on. Turn it off, turn it back on.
Fucking hell. No. No.
Had to bring some batteries.
And did you talk to Kimberly? Is she still?
No, I don't have anything from her. She must have-
No comment.
They must be still going on. Who's saying it?
Back's got it on speed dial.
Approximately the same likelihood.
Like the master.
Look at that real quick. I found it in 5 minutes. I'm yours. Go ahead.
So I've been wearing, so.
I go barefoot in the airport. I'm just not afraid of cooties.
Yeah. I'm not holding that.
I caught this.
Before I was like pretty cautious.
I know a lawyer who just died.
Yeah.
He had, now I will tell you, he had some pre-existing stuff,
Whatever.
not pulmonary as far as I knew, but.
Okay, here.
Yeah.
One of the things he said, did he tell you he was going to buy it in his own name? or
He's also-
company's name?
he's
Well,
also
I
a
didn't
good-
ask him that, so I didn't
whole
understand.
thing
I'm
was on
selling
the-
it to him, so it doesn't, to me, it didn't make any difference.
The whole virus.
Yeah, mine are. We're at 5 and 8. So. They know as soon as they can get it.
Okay, who was selling it? He didn't care what kind of deal I had.
My photos now.
Come on.
Yeah.
They don't really charge.
It's not, but.
It's true. But you're like, yeah,
You can stay standing. When our court reporter returns, we'll, no, you can stay seated. I'm sorry. I meant you all don't have to sit. You can stay seated. You don't need to worry about that. I'm sorry. That's not what I meant.
I was standing.
Yeah, I had looked this way first and they were you don't need to sit. You all don't need to stand. We need our court reporter. When she gets back, I'll see if you all are ready and then we'll get our jurors. So at ease.
Have you had a chance to look through this?
No,
We have to go through the extra procedure.
right. Give me a,
You wanna look at all of these?
yes. I'm having a little bit of technical problems. My mouse ran out of juice.
So there's an iPhone in the waiting room. Would that be Mr. Vaknin of Zoom? You can't see him because I have to let him. That's Mr. Vaknin? Okay. I'm going to leave him in the waiting room in case anyone's in touch with him, not just because he shouldn't plug in till we're ready.
Just get,
Okay.
okay.
You have a second and then let's get going.
Look at volume 1. Let me just see. Let me just call them out.
We put one on the witness stand.
That would be the easiest thing to do.
We did give one to the judge.
One,
Judge has one.
5.
Oh, so you have the cheat sheet.
It's like a cheat card, but yes, it's very thick.
I don't know what's up with that weird stuff in the printer.
Yeah. It's going to cost your client. That's fancy paper.
5, 4.
No, I'm good. I wanted to, because I didn't, because
I saw
Mr.
2 and 3
Beckman
in
doesn't
there
have
too.
books, I don't have the volume.
Oh, but she needs, I was going in the order she gave it
Yeah,
to me,
but I'm
so.
just giving
So
to
in
them
order
in
for
order.
the judge to find them, he needs the
One,
cheat sheet, or I have to remember. the
2,
time.
3.
No, this is great because now you just have to say the exhibit number and I have the secret decoder ring and can know which volume.
Right, well, that's why we did it, so we can say to the
1, 2, 3, 4,
clients too, so you
5.
can say, pull volume 7.
One.
and
Yep.
then exhibit 22.
1, 2, 3, 4, 5.
Trying to be efficient.
2, 3, 4, 5.
Mhm.
What else?
7, 8, 9.
Odyssey's not working for me
I don't
right
look
now.
black today, so it wouldn't be twinsies.
We're in black tomorrow. I told you today was blue.
I know, that's why I wore black.
Yeah, you weren't here yesterday. We showed, and we had the same color on it.
It was like maroon.
It's a maroon color. It's like an unusual color. It was exactly the same color. It's like, oh,
We figured it was firm colors.
Right. Team.
no, blue. Blue is a burn color. kind of humorous.
Okay, 789, then 25.
So it seemed like the kind of person who's up over. I used to play polo.
And after 25, it's 30, 31, and 32. And that's it. 30,
No, I used to play
31,
polo.
and
When I
32.
played a long time ago. The scoring was different. You had to work your way up to be a zero. Like you started like a -4 or something. So like, I was super proud when I got to be a zero.
Is that in the next one?
I did it. I grew up in Detroit. And I grew up like in Detroit. Yeah.
Polo there.
You said you've been looking for 32. Yeah.
Search that one out.
I wouldn't guess.
I was not video.
Oh, are they all on there? Yeah, so is that a feature I can do?
Yeah, usually we just write.
It should, it says they're hidden. Where are they not? Is it on the big screen there?
Okay. So we'll just.
Okay, because my default right now is they're hidden, but I'll go into the control world and see.
Yeah, and you know, it'll be easier with the witnesses here.
You think so?
It'll be easier with the witnesses here. Because, you know, say it turns to 27.
Yeah, it's not listing that. It's got speaker view, gallery view, show non-video participants. Oh, no, and now they just, it doesn't let me unhide non-video participants. Let me see. I can spotlight for everyone. So like on the big screen, it's showing there's someone who just has a C on it. Like, okay, let me see if I can do that in the control. Yeah.
Court wants us to do something.
Did he sign? Fine.
It's a little different because.
Now it should just have the speaker on it, the big one.
This is literally,
I'm less worried about the podium one, but the giant, I can't see the giant one, but it should,
It's only got lunch.
good, okay. Because that way it'll show it should show that when the witness is talking, it'll have the witness on there big. We'll keep working on that. Okay, yes, ma'am.
So Mr. Kendall and I have talked, and for the exhibits for this witness, he's agreed that they can all be admitted. So
Okay.
if it's okay with you, what we'll do is we'll say, I want to show you exhibit 27, and we'll just display it, and I'll offer admission of exhibit 27, or we can pre-admit.
Why don't you just, when Mr. Vaknin, after he's sworn in, say, Judge, we'd like to tender exhibits, whatever they are, and if it matches the list you shared with Mr. Kendall, I'll ask him if he has any objection, and then they'll be in. That way we're not publishing and then admitting, but if everyone's agreed on it, that's a very efficient way to do it.
Technically, do you want me to stop sharing? So that it doesn't take over the screen, or is it going to be a split screen?
So the way we worked at the last trial that was effective was that on the screen, big was what was being shared, and then the person who's talking is little. Like when Ms. O'Neill was giving her opening, we'd see the PowerPoint and she was on that big screen. And I think that will be what happens if you're sharing a screen and Mr. Vaknin is talking. He will appear as a small tile on the screen, but the exhibit, which is what folks are asking about, will be there. Once there are no more questions about the exhibit, you should stop sharing, and then Mr. Vaknin will get big again.
Okay.
Okay, sure. All right, Mr. Kendall, ready for the jurors?
Yes, I am.
Ms. O'Neill,
Yes.
let's do it.
So you just put the paper on and then. Because before they could just give you like a stack of documents. You know, you could check on there or whatever. It's not as exciting to watch. But.
I'm gonna try really hard to remember I'm the plaintiff. I'm like never the plaintiff. So if I say defendant, please correct me.
Ms. Tucker will need to give you a hand sign because I won't be correcting you.
She's not gonna remember it either. I was trying to think, it's been a while, it's probably been 4 or 5 years since I got to go first.
I've never had a plaintiff's case. This is my first.
I
one.
started out as a plaintiff civil rights lawyer.
Oh, that's fun.
Yeah, I actually worked for this really, really, really good guy. His grandmother's very tenant. He went to the United States Supreme Court twice.
Nice.
Yeah, great guy, super guy. Jim.
Good if you can get someone to fund it.
Thank you, Deputy. You all can be seated. So you survived your first break. We didn't keep you there for an hour this time, but thank you for letting me know that you needed a break. It is now the plaintiffs, D2 and the Daltons, time to start presenting their case, and they'll do that by calling their first witness.
We would call Abraham Vaxton to the stand.
So members of the jury, Mr. Vaknin is appearing remotely. He will appear on the screens throughout the courtroom, the big one that you all can see. There may be one other witness who appears remotely. Most witnesses will be appearing in person. It is perfectly okay to have someone appear remotely if both sides agree, and it has been agreed to here. So I'm going to add Mr. Vaknin to the Zoom session that is connecting all the computers in court. And hopefully he will appear on that screen. He'll be put under oath and be testifying like any other witness who will be appearing in person. Fingers crossed.
There he is.
Mr. Vaknin, can you hear me?
Yes, sir, I do hear you now.
Great. I'm Judge McBurney. Welcome to courtroom 8D. I'm going to have Deputy Gordon swear you in just a moment, and then you will be subject to examination by Ms. O'Neill and by Mr. Kendall. And you can stand where, is he not showing up on that big screen? Uh-oh. What's on the big screen? Okay.
B.
Okay, when he's talking, he is, but you can do it from right there. That's fine.
Did you raise your right hand for me? Do you swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth?
Whoops, he needs to, I clicked the wrong button. You need to unmute. I apologize. That won't happen again.
I
There.
swear.
Could you state and spell your name for the court?
Abraham Vaknin,
Can you spell, you can put your hand down now. Thank you. Can you spell your last name, please?
V as in Victor, A-K-N-I-N.
Thank you, sir. Ms. O'Neill?
The plaintiffs would offer into evidence exhibits 30, 32, 4, 31, 1, 9, 2, 3, 5, and 7.
So first, importantly, Mr. Kendall, any objection to those exhibits?
No, yeah.
Okay, they're admitted. In the future, if it's not too complicated, if when you're rattling off the exhibits you want to admit, you could put them in numerical order. It will be a lot easier for us to keep track of what's in and what's not. But
Do that.
those
Okay.
exhibits are all admitted,
Thank
and
you.
you're free to publish any of them as necessary.
Good afternoon, Mr. Vaknin. Can you hear me okay?
I hear you fine. I just don't see you. I used to see you before. I don't know what happened here.
Well, the important part is that we see you.
Okay, then I hear you fine.
Okay, good. Though he's gonna need to be able to see exhibits.
Exhibits he'll see.
Okay,
If you
all right.
share screen, he will see the exhibits.
All right. Mr. Vaknin, can you tell the ladies and gentlemen of the jury where you are today physically, what state?
Well, right now, we live in New Jersey, and I'm retired, my wife and I.
Are you familiar with a company called Atlanta Beverly?
Atlanta Beverly LLC, that's correct. It used to be our company.
Right. How about a company called Atlanta Plaza LLC?
Same thing.
Right. When you say used to be our company, who owned them?
My wife and I.
Did Mr. Hyder or Bristol Consulting ever own either of those companies?
No, we sold them the properties, but not the companies.
Was Mr. Hyder ever authorized to act as an agent of Atlanta Beverly LLC or Atlanta Plaza LLC?
Never.
Did Atlanta Beverly LLC and Atlanta Plaza own any property in Georgia?
No,
Did they used to own property in Georgia?
that's correct.
Where was that property located?
And Verbena Street,
And can you describe for the ladies and gentlemen of the jury what kind of property it was?
there were two sections of it. It was one part was the commercial. There were few stores. If I'm not mistaken, there were 8 stores. Some of them are active and some of them are needed some more repair and fix. And the other section, it's 277 apartment units, which they were closed and needed to be repaired and bring them back to normal.
Are you familiar with a gentleman named Donnie Hyder?
I met him in, I believe, him or his brother in 2018.
In 2001?
2018, I believe, in the court.
Okay. Are you familiar with a company called Bristol Consulting Group?
Nope.
Did Mr. Hyder come to your house with respect to buying the Verbena Street properties?
That's correct, ma'am.
When was that?
I believe it was April 30th, 2016.
Right.
He came with his family, very, very nice family, with his mother, I believe, was there, and his kids. And it was very nice conversation. He impressed me that he's the guy who can fix he can fix the units. He showed me also proof that he has funds to do that. And I was really, really very impressed that he can do the work.
When you say he impressed you that he's the guy who could fix the units, can you tell the ladies and gentlemen of the jury what you mean by that?
Well, he presented me that he has enough funds, and he told me that he does have storage. He showed me a letter from the bank that he has $6 million in some change. And he promised he will close in 15 days. I mean, I couldn't be more happy than he was the best candidate to do that, to fix, to help, and put the buildings back together to normal
He said he would close in how many days?
in 15 days.
And can you tell the jury what properties Mr. Hyder was interested in buying?
The two properties, the apartment buildings and the commercial section.
Did he tell you who was going to be the purchaser of those properties?
Only him by himself.
Did you believe that there was a financing contingency or anything that had to be created?
Never, and he emphasized it's all cash deal and he has the money. And he convinced me and he showed me a paper that he does have the money. So I was definitely impressed and happy that finally someone can come and buy the property.
Had you tried to sell them before?
I did.
I'm going to show you on the screen. You should be able to see it, a document we're going to mark as Exhibit 30. Can you see that document we've marked as Exhibit 30?
Correct.
Is this a document you've seen before?
Yes.
Can you tell the ladies and gentlemen of the jury what it is?
This is piece of paper that he wrote it in the last few minutes before he left. And he made me to sign, and he had to sign. And that's it.
And what's the purchase price that you agreed to that day?
It was 1,001,100, and he gave me a deposit of $5,000.
Down there where it says seller, do you see that? Is that your signature?
In the bottom, yes.
Yes. Is that your signature there?
Yes, ma'am.
What's the date written by your name?
April 30, 2016.
Were you present when the signature was put in on the buyer line?
To be honest with you, I'm not sure, and I don't think so.
Right. Do you know why the date by the buyer's signature is 6/30/16 instead of 4/30/16?
Probably, I'm assuming he wanted to just gain some more time.
Did you agree to that?
No,
What property was included in this offer to purchase for 1.1 million?
well, I believe like 6 multifamily properties, which they were completely dysfunctional, and the commercial building.
At any point, and ultimately, Atlanta Plaza and Atlanta Beverly sold these properties, right?
I sold them to him, correct.
All right, at any point between the date Mr. Hyder stood in your house and when they were sold, did you ever have any conversations with my clients, John or Brian Dalton?
No, he never introduced me. I never knew him. And I don't know. It's fishy why he didn't do it.
You can take that down, Jack. Did Mr. Hyder ever tell you that the actual purchaser was going to be somebody other than him?
Nope.
What authority did you, if any, did you give Mr. Hyder to order appraisals or reports in the name of Atlanta Beverly or Atlanta Plaza?
Never. I never gave him any permission even to go to the property. I never gave him a permission to go to and bring appraisals. We shook hands. The deal was done. He said, I'm living there. I saw the property. I spoke to the city. I know what has to be done. The deal is done. I'm paying you the money. I'm going to fix it. And I have the funds and the sources to do that. Today we know everything is different, but that's exactly more or less what he told me to do.
And did you get your funds within 15 days of that meeting with Mr. Hyder?
No, and his lawyer, I was calling her, I don't know, dozens of times, and I almost, in fact, just about all my hopes. It looks like it was useless, and we got to move on.
All right, I'm going to show you a document that we're going to mark as Exhibit 32. Can you see this document?
Yes.
All right, and this is an appraisal that you saw back when we took your deposition in December of 2018, true?
That's correct.
You remember looking at this?
Yes.
Did Atlanta Beverly LLC ever retain MBA appraisal services to do an appraisal on the Verbena Street property?
Never. Either them contacting to me or me contacting them. There was no communication at all whatsoever. In fact, up to now.
And it says it's prepared by a gentleman named Gordia Ammons. Do you know Mr. Ammons?
Never met none of those guys.
Did you ever talk to Mr. Ammons?
Never.
Did Mr. Hyder ask your permission to get a appraisal done in the name of Atlanta Beverly LLC?
He never asked me, and I told him very clear, and before even we signed any agreement, that not to go into the property because it's unsafe.
If you can look at, I'm going to show you page 4 of the report. You see it has an as-is market value and an as-proposed market value. You see that?
I see it, but I cannot, oh, now I see it better, correct.
I'm sorry, say that again, sir?
Now I see it, ma'am.
Okay. As the owner of the property, did you think this was the as-is value of the property and its potential value in 2016?
Never, never.
Why not?
It's not even close to it. Well, from simple reasons. First of all, I advertised it myself for selling it more than a year, in fact, couple of years. And I never were close to these numbers. So it's extremely fishy how they receive this number. I would like to understand how they got to this number. I think it's, in my opinion, they created for something. No one would appraise it for this price, never.
How long had the property been on the market before Mr. Hyder came to your home?
Believe it or not, for a few years.
Did you have any active offers on the property during July of 2016?
I don't know what you mean by active. I do have phone calls. I did have some different proposals. But to be honest with you, it's not easy to find a strong guy to have the money to buy it and fixing it, and to be a local guy to go to the city, get permits, and do the work. He was the guy when I met him in my house, the perfect guy to do the job. But down the road, I found out that I was wrong.
Why did you think he was the perfect guy? Mr. Hyder is who you're talking about, right?
Mr. Donnie Hyder, correct.
And why did you think he was the perfect guy to do the project?
I think he had the knowledge. I think he had the money. This is the most important.
Man, we need to document this in the record.
Nobody came with an offer that he offered. And he was a local guy. This is the most important too.
Do you know a person named Crystal Kimbrough?
Yes.
Who is she?
She was his lawyer. She was okay in the beginning, but then she disappointed. She very disappointed me. And I don't like to talk bad about people, but I'm in this business for many years. There was a disaster to work with her, and she was going around. You won't believe it. I don't even have the hard one up till today. I don't have the hard one. For years, my CPA is asking me, I need the hard one.
You don't have the HUD one for this property that you used to own? Is that what you're saying?
That's correct. We did the sales. I mean, I sent everything to her overnight. I follow her the directions. They wire the money, but I didn't get the HUD one from her.
Did you ask her for them?
Of course, I emailed her. I mean, I can send you the emails. I sent her, I called her dozens of times. In fact, one of her answers, she said, her client told her not to do it or not to, I don't know, very weird answer. I mean, it's a hard one, for God's sake. I need to show it for my taxes, and she couldn't give it to me.
I'd like to show Exhibit 2. Can you see Exhibit 2, Mr. Macklin?
Can you make it larger? Yeah, okay, now I see that.
You see it?
That's correct. Yeah, this is one of my email that I sent her.
To Ms. Kimbrough.
Hold on, yeah.
And this is in May of 2018. Why were you sending Ms. Kimbrough an email in May of 2018?
Because I didn't have it. I need the hard one for my taxes.
From your perspective, what was the closing date for the sale of the Verbena Street properties?
April 26, 2016.
April? April, is that what you said?
No, I'm sorry, June. July 26, I apologize. July 26, 2016, I apologize.
And by May of 2018, you still didn't have the documents that you needed?
I didn't have anything.
I'd like to,
In fact, I complained and made phone calls one after the other. I don't know if I can tell you or not, but to be honest with you, she gave me impression that she works with them, with him and his family. That's the impression I got, because I thought she's presenting us, but it looks like she presented him than me. I got nothing I can show it to you with emails that whatever I requested, I never received from her. And she was keep pushing the closing, pushing. And at one point I said, if it doesn't work, just forget it.
when you say that you thought she was representing you, what do you mean? Who is she?
Well, for the closing,
Who is she when you make that statement, sir?
I forgot her name, Christina,
Miss Kimbrough?
Miss Kimball, correct.
And when you say that it turned out, in your opinion, that she was representing him, who is him?
Donnie Hyder.
I'm going to show you a, well, why did you think Miss Kimbrough was representing you in this transaction?
Well, for the closing, and I honestly, is the easiest closing it should be. I mean, there is no inspection. The city are very friendly. You can go to them; they'll give you all the information. So it was very clear. There's nothing complication as far as buying a property. So it's okay if she was presenting both of us. But she didn't present me in the right way. I found out every time when we get these closing, I found out she's working with him rather than she works for both of us. She didn't do really work for both of us.
I'm going to show you an exhibit that we've marked as Exhibit 4. Can you see that, or we need to make it a little bit bigger for you?
If you don't mind, yeah, it's too small, I cannot see it.
How's that? Can you see it now?
Okay, yes.
And is this a copy of an email that you sent to Ms. Kimbrough on June 6, 2016, requesting information?
That's the email I sent her. Yes, that's one of the emails. That's one of my communications with her, correct.
Mr. Vaknin, I think your hand may be on the camera a little bit. Can you move? There we go. Thank you.
Oh, I apologize.
That's okay.
Hold on, I got to pull out the document. You say in here, in this email, I spoke to Donnie and explained him my concern about this transaction since it's been almost 5 weeks and does not look like we are closing as promised. What were your concerns that you had in June of 2016?
I start feeling that all it was full of baloney. He probably doesn't have the money to buy it. To be honest with you, I mean, if a guy leaves the meeting in my house with so much confidence, I'm sending you the check in a few days, we'll finish it, and it will be less than 15 days. And nothing. Beside his email, he was ignoring me for weeks. All kind of stories. He really actually ignored me. And there's a little bit rest. Some thinking from my side, is the guy for real, or maybe he found something else and he doesn't want to deal. So, and I told her in one point to Christy, who she knew him, I said, I don't mind, I'll send him the $5,000 back and just forget it, let him move on and let me move on.
I want to show you another part of this email we've marked as Exhibit 4. Jack, if you could go to the email from June 5, 1047. We're going to kind of go through this. Joy's going to get to look at the whole document later, but in order to show you, Mr. Vaknin, we're going to pull out the part that I want to ask you a question about so you can see it. Can you read that?
Yes.
Is this a copy of an email that you sent to Ms. Kimbrough on June 5th, 2016?
Well, there was an email she sent to me.
I'm sorry. Yeah. Hello, Mr. Vaknin. This email, we highlighted the wrong one, so we'll go back and do that. Hello, Mr. Vaknin. This email finds you well. In connection with the acquisition of Atlanta Beverly, please identify the requested list in the attached PDF. Did you do that? Did you respond to her email and give her that information?
Of course. This was on June 5th, 2016.
Right. So we'll scroll up a little bit. Do we see right above that your response?
Correct.
Do you remember what items weren't applicable to the transaction that Ms. Kimbrough had included in her email? Do you remember, sir?
I'm trying to think very hard, but I really don't.
Okay, let me show you a document we're going to mark as Exhibit 8.
When you say you're going to mark it
Oh,
as
yeah, I
exhibit.
did. Let me show you. We've marked as
Okay.
Exhibit 8. Thank you. I'm sorry, Your Honor. I'm going to show you a document we marked as Exhibit 8. Mr. Vaknin, is that your handwriting on the front page of this fax?
Yes.
All right. And if we could, I'm just going to show you the second page. I'm going to highlight down there at the bottom under number 1.
Can you
Is
make
that
it
your
bigger?
handwriting down the right side?
I believe so, yes.
All right. I'm going to show you on page 2 to ask you just the same question. There's a lot of pages here. I'm not going to go through all of them, but we'll show you page 2 and ask you the same question. Is that your handwriting down there on the right side?
Yes.
All right. And did you fax this information over to Ms. Kimbrough to tell her what was and was not applicable?
That's correct.
One of the things she seems to be asking you about stock certificates and things related to the companies. Were you interested in selling the companies?
I didn't understand the question.
In 2016, were you interested in selling all the shares of Atlanta Beverly or Atlanta Plaza?
Not the shares. I didn't want it to touch I wanted to sell the properties. Let's put it this way.
Did the property get purchased by June 30th, 2016?
No,
You already told me it didn't. You told me it sold in July.
July 26, correct.
Why did you agree to sell it to Mr. Hyder, even if he didn't get the money to you by June 30th as he had promised?
I want to be honest with you. If I had somebody else, I would just sell it to him, but I had no choice. He was the only buyer, and and thank God came to the end.
Did the terms change at all?
Did what? I'm sorry.
I'm sorry, I didn't hear you.
I didn't hear the question.
I said, did the terms change at all?
From where?
From when he met in your house in April to the day that you sold him, did the terms change?
Well, I changed, the only thing we changed is that I believe the taxes And we increased the price from 1.1 to 1.2.
And can you tell me why you did that?
Because I found out that the taxes we owe was almost like 70,000 or something like that. Because the taxes was not paid.
All right, did anybody agree that you could change those terms?
I told him that and he agreed, yes.
When you say he, who is he?
Donnie, Mr. Hayden.
All right, I'm going to show you what we've marked as a document, as Exhibit 1. Make that bigger so you can see it. Can you read that, Mr. Vagnon?
Correct.
Is this a copy of an email that you received from Ms. Kimbrough on July 26th, 2016?
Yes,
And it says, please find the revised HUD 1. You'll notice your closing costs have been reduced to reflect the agreed upon amount of $70,000. What did you understand that to refer to?
that they accept the offer and they change the HUD.
Can he
Oh,
repeat?
can you repeat your answer, Mr. Vagnon? The court reporter didn't hear you.
Yeah, I understood that she changed the numbers in the HUD, so this way I will have the extra funds that I requested.
Were you sent some documents to sign for the closing?
Before the closing?
Yeah.
I believe so. Yes, yes.
I'm going to show you a document that we have marked as Exhibit 31. Is that your signature here on Exhibit 31 for the owner's affidavit?
Correct.
And who owned Atlanta Plaza LLC? Did you own it or did your wife own it?
Well, it's under my wife's name, but we owned it. But
Yeah,
to be
that's-
specific, it's under my wife's name.
All right. And I'm going to show you, hold the wrong document. I'm going to show you a document we've marked as Exhibit 25. Is that your signature on this document?
Yes, ma'am.
Can you tell me the day that you signed this document? Dak,
I believe it was the 26th,
of?
April 26, 2016.
Did you sign that owner's affidavit we just looked at on the same day?
Yes,
Did you sign any documents to sell the property, any warranty deeds in June of 2016?
Juno.
I'm sorry, sir? Can you say that again?
No,
Were you out of the country at any time in July of 2016?
no,
Did you ever have to go to an embassy to sign documents related to this closing?
no, no reason.
Have you ever had to go to an embassy to have anything notarized ever?
No,
How would you characterize your dealings with Mr. Hyder regarding the Verbena Street property?
I personally think he's a nice guy. His family, they're very sweet. I mean, the kids, everybody. But there is something bad about this guy. He wants to make a shortcut and to make fast money by doing wrong things. And I feel sorry for that because the guy's capable, he's smart. And personally, I like him. But I never knew that he's so shrewd and doing something to hurt him and to hurt his family. I'm really shocked. Why people who can do it differently? I'm working hard for the last 40 years. And you can make it. This country, you have the opportunity. Work hard, you can make it. Let me tell you, if he was doing nothing, the property that right now will be worth it maybe 4 or 5 times that he bought it from me. Just doing even nothing, just keep it clean. He's in Atlanta, he could just keep clean and make the community happy. So I have bad tests from the guy. I will never do business with the guy, and I think he got to a level that, in my opinion, it's a criminal level.
Do you believe that Mr. Hyder made misrepresentations of facts to you regarding this deal?
Everything was lying, everything. Again, maybe he has the money. I didn't see that. Everything changed. Whatever he told me, it was completely lie. I was so happy. I told my wife, we got the person, the city, the town will be happy with him. He's going to take this property. He's going to fix it. And he's going to make $10-15 million if he's smart and doing it. And I was so happy, you have no idea, especially when he broke his family. And I said, the guy is very serious. And he took his plan, according to him, to come down here to see me. Everything in the end looks completely full of baloney. It's a lie. It's a big lie. He took the property. He wanted to flip it and make fast money, and anything possible wrong, he did. And I really, to be honest with you, I don't understand why. There's so much value and potential. It was when I sold it to him, and it was a good price, fair price. All what he had to do is work a little bit hard. The city was waiting for someone come and fix it, and especially a local guy. They were very happy. I have no understand where these was criminal things got to him. I have no idea.
I'm going to show you a document that we marked as exhibit number 5. Can you highlight the top part? Yeah. I showed you this document at your deposition back in December of 2018. Do you remember that?
Well, you're right. Yes, that was the first time I've seen it. I got out of it.
Right. Do you know what Atlanta Beverly Inc. is?
There's no such thing.
Have you ever had a company called Atlanta Beverly Inc.?
No.
All right. If you look down there at the purchase price,
I see it.
Did your company Atlanta Beverly LLC or Atlanta Plaza LLC ever have an agreement to sell the Verbena Street properties for $3 million?
Never. I never even were close to asking this price.
I'm going to show you another document that we marked as Exhibit 7. Bottom. Oh, no, in the middle. I'm sorry. I misdirected you, Jack. I'm sorry. See there now under purchase price, it says purchaser to acquire 100% of the shares of the LLC.
Yep.
Do you ever agree to sell 100% of the shares of any of your LLCs?
Never.
All right. And if we look down at the bottom, under seller, is that your signature?
No, you saw before how is my signature. I don't sign like that. Never.
Did you give Mr. Hyder authority to sign your name?
Never.
Did you give him authority to sign Atlanta Beverly?
Never,
How about Atlanta Plaza?
never. I will never give him a power to do anything. I mean, why will he sign for me? I don't want him to sign for me.
Right. And if we look at the top of this document, back where we started on Exhibit 5, where it says Atlanta Beverly Inc. and/or assigns and nominees agrees to sell buyer John Dalton and/or designated LLC the following properties. Did you ever agree to sell a property to John Dalton or a designated LLC?
I never know the guy until 2018, when we were in the court together on a different case.
And that's the case actually where my clients were suing you for what they thought was something you'd done wrong about the Verbena Street deal, right?
That's correct.
Right?
I never met him before.
Did you ever make Mr. Hyder your assign or nominee?
Never.
Did Atlanta Plaza or Atlanta Beverly ever make Mr. Hyder its assign or nominee?
Never.
How about Bristol Consulting? Did Bristol Consulting ever get to be an assign or nominee of Atlanta Beverly?
Never. I had no reason to do that.
How about Atlanta Plaza? Was Mr. Hyder ever an assign or nominee of them?
Never.
All right. Did you ever reach an agreement to sell just the retail parcel?
No.
Did you ever-
Absolutely not.
Why do you say absolutely not?
Because they had to come together. The only reason I sold them, he was far from me. The communications was hard, and request someone to be there full time to take care of those two properties. It will never make sense to sell one and leave the other one. Absolutely not.
All right. Mr. Vaknin, that lawsuit that you mentioned before, where my clients and Bristol Consulting filed a claim against you related to the Verbena Street properties, you reached a settlement with my clients, true?
That's correct, ma'am.
All right. Anything about that settlement require you to come in here and testify against Mr. Hyder?
I didn't understand the question. Can you repeat that?
Yeah, let me ask you a different question. Is everything you told the jury today true?
The whole truth and the whole honest truth. I have no reason whatsoever to lie or say something differently.
That settlement agreement that you signed with my clients, did that make you want to come here today and lie?
Definitely not.
Those are all my questions. Thank you, Mr. Vaknin. Mr. Kendall may have some questions for you, so you need to stay on the line.
Yep,
Thank
stay
you, sir.
put, stay put, Mr. Vaknin. Mr. Kendall, your turn.
Mr. Wagner, how you doing today? I'm Wayne Kendall.
Yes, sir. How are you? I'm doing good, sir.
I'm doing fine. You and I met some time ago when I took your deposition back in December 2018. Do you remember that?
Yes, yes, I do remember you, sir.
Okay. I'm trying to understand some of your testimony today. You know, particularly what you say about Mr. Hyder. You know, in one sense, you say he's a good guy, great family, and then you start talking about, you know, that he misrepresented things, and actually you use the word criminal. Now, tell me what exactly Mr. Hyder misrepresented to you about the sale of your properties out there on Verbena Street.
If he bought it for me and he sold it, it's a different story. But he put me in the spot that I know that he has another partner and some other investors, and they're buying the property from me. That's boiling my blood. That never happened, and it makes me the bad guy. I'm doing this business for 40 years. I want it to be clean. I want people to love me and to be honest. I love this country and I love the people. I don't like people lying. I was never knowing about these people who he brought to the table. He did it behind my back. He really actually pretend and he forced the information. He completely false. He said that they are the buyers. He's not the buyer, like some more people buying it. It's not true. I sold it to him. Whatever he wants to do after that, he can do. I have no problem with that. But here's the thing also, sir, what makes me so mad. You make a closing, and I did many of them. Why the hard one, I cannot get it? I need to pay my taxes. I need to present it to my CPA. I didn't get it. You know how many times I called Christine, his lawyer, and she was running away from my answers? Everything made very clear. They don't do anything kosher, not something illegal. So to be honest with you, my love to him, it's not there anymore. It's not there anymore. They had the opportunity to fix it and make it in the honest way. That's not what I see. I'm sorry. That's not what I see. Here, right now, we saw $3 million. Never we discussed. We never even were close to this number. So you tell me what I'm supposed to do, to hug him and love him for doing such things? No, I'm not.
Okay, let me try to break that down a little bit. What I heard you say is that you didn't get a HUD one.
No.
Okay, but Donnie Hyder doesn't produce HUD ones, does it? That's the job of an attorney, a closing attorney. Is that right?
Yeah, but I have the email from her. Okay, and you probably seen it also. She's saying she cannot disclose it because her client told her not to do that. I never heard about it.
No.
You are the lawyer. You told me when we close, we do closing. Don't you think I'm supposed to have the HUD one?
What email said that her client told her not to send you a HUD one?
Well, I'll be happy to send it to you. It says very clear in my last email that I sent it.
Was it one of those documents that Ms. O'Neill just showed you?
Probably she does have it. Otherwise, I can show it to you black and white.
Okay, now let me ask you this. You signed an agreement with Donnie Hyder to buy this, to sell this property, right?
Correct.
And I believe that was exhibit number 30. Can I see exhibit number 30 again, please? Yeah, your exhibit number 30. You showed it, you put it up.
Yeah, just a moment.
Hold on a second. So you are asking them to display exhibits?
Yeah, because it's been published. Anybody can see the document once it's been published.
Of course, but why aren't you putting it up? Why are you relying on them to put it up?
I can put it up. I mean, it was easier for them. I've agreed to it.
Okay. We'll talk later. For now, if you don't mind putting up 30.
It'll take you just a second.
Okay.
I don't have a problem with them using my documents when I put them up. It's just a lot easier.
You're missing my point, but we'll talk about it later.
Okay.
Number one, should be number one. Oh, right here.
I think I've dropped out of the meeting.
We're not in the meeting anymore.
Yeah.
Okay, so
I have a hard copy of it. We can pull it up on the document. We can share my screen.
Yeah, I do.
That can be reached there.
If you weren't remote, I could just show it to them. I mean,
right. And so what we had talked about is the way you share exhibits actually for non-remote, so the jurors can see it, is with your equipment, you put up, you've got all the exhibits electronically as well. And so your team is in a position to know what you want to do rather than the other side. And so you'd say, I'm ready for 30, and your team shares the screen, and there it goes. It sounds like they have effectively unplugged from the system at this point. We can get them back in.
Are we on one system?
I was really was slow then. Thing.
So the internet is running slow.
Yeah, the internet.
You know that problem?
Yeah, just still not thinking.
I have the internet, but I mean the link, you know. Put you back on there.
Yeah, let's back and back. Okay, let's go to.
Third party. And then go to 30. That's the document right there. But how do you plug into that?
You have to be on the Zoom. You got it?
We're still trying to paint. I'm still waiting for it to come up. Okay, number 30.
30.
Just 30.
I'm sorry.
True.
Zoom.
I have the Wi-Fi device.
Yeah.
The internet is buffering.
We're on the internet issue.
So it's Fulton Public.
No, we're there. It's just that when we click on it, it's just taking,
There it is.
yeah.
Can you share it?
Well, let's see.
Okay, I'm trying to share it now.
Yep, I'll let you in.
Okay.
You're in the meeting now.
Thanks.
Welcome. You want to turn your audio off? I'll help out.
You have to click up there with the thing and hit it.
Okay.
Share.
As soon as I get back.
No, I'm just saying, you get in the folder, you can just go.
That's the machine.
It's buffering again.
It's true. No, that's not good. Yeah, share.
Is it down here? Yeah, so I'm looking at that share right there. Yeah. You do desktop, try to. Share.
Is the big screen still on? I just turned off its
Click
camera.
on it. Try to click on
Hold on, good.
It's grayed out.
So Mr. Kendall, do you have other questions for Mr. Vaknin? You can come back to this while your team sorts this out.
Yes, I can.
Great.
Try to share again.
Mr. Wagner,
Yes, yes, sir.
Ms. O'Neill asked you about and showed you a document regarding the appraisal. And you've been in the real estate business a long time, right?
Yes, sir.
Okay. Have you ever done an appraisal on well, there we go.
Okay.
Let me just finish that line of questioning. Have you ever done an appraisal on a property that you were purchasing?
Object to the form.
The objection was, pardon me?
I object to the form. It lacks foundation. Hasn't established that Mr. Backman's qualified to do a.
Okay, that's not how I understood the question, but maybe you meant, have you ever had an appraisal performed?
Exactly.
Okay.
That's what.
Alright,
Have
my
you ever
apologies.
had an appraisal performed on another property that you were purchasing,
Yes, sir.
that you did not own at the time you were purchasing that property?
Yes, sir.
Okay, that's not uncommon for a purchaser to hire someone to perform an appraisal on another piece of property that that person who's purchasing the property does not already own. Is that right?
Absolutely wrong. You get the permission, you got walked into the property with the owner or some of his representatives. You make sure the insurance knows about it, especially when a property was falling apart. Absolutely, I disagree with you. I've done many appraisals. Yes, you got to do it the right way. The owner should know. They should tell his people, walk them around, make sure there is security, make sure it's safe. You just don't go and walk inside the property without the owner knowing. I'm sorry, sir.
Okay, well, what I'm asking you is not so much the manner in which the appraisal is done, but have you as a purchaser, a potential purchaser, hired someone to do an appraisal irrespective of the manner in which it was done in terms of the approvals of the existing property owner? I'm just asking you, have you as an owner, a purchaser, had
with permission and the right regulations, the way to do that.
All
There's
right.
a different way to do it than your client did.
Okay, good. Now, let me go back to this document that's on the screen, exhibit number 30. I
Correct.
think, can you scroll up, show the signatures? Okay. Now, Ms. O'Neill asked you about this document, and that you said that this is the document that Mr. Hyder wrote up when he came to your home up in New Jersey. Is that right?
Correct.
Okay, and you signed this document and he signed this document, right?
That's correct.
Now, that document says closing 60 days, right?
That's the way he wrote it here.
Yeah, and you saw that was on the document when you signed it, right?
On this document,
Yeah, on this document, 60 days.
yeah, he wrote the 60 days, not me. He wrote
Okay,
the 60 days.
and your signature, the date looks, it looks like, I can't tell if it was a 6 or a 4, but I think your testimony was you signed this document on 4/30/2016?
Correct.
Okay, so from 4/30 for 60 days, that would be roughly June 30, is that right?
That's correct.
So you expected to receive $1.1 million less the $5,000 earnest money on June the 30th, is that correct?
It's absolutely not correct because we agreed in 15 days to get paid. Whatever he did after I signed, I'm not obligated to that. But regardless, we closed almost 75 days, not 60 days.
Okay,
More
well,
than
that's,
70, almost 80 days we're closed.
okay, that's what I'm trying to get to. Did you or did you not agree to the 60 days?
Absolutely not.
You didn't?
No,
So what is your testimony then? Does he somehow put the 60 days in there sometime later?
no, we spoke about it, that closing in 15 days. That's why we spoke about it.
But you signed a document that says 60 days.
He wrote the 60 days, not me.
But you signed the document.
I signed the documents and then he put 60 days. He could put 160 days. I don't know whatever he put there. I didn't agree to 60 days. It was very clear, 15 days. Even the title lady knows about it. We wanted to close it in 15 days.
Okay, you actually closed though on July the 26th, right?
That's correct.
And at the time you closed, instead of receiving 1.1 million, you actually received $1,230,000. Is that right?
No, I didn't receive that amount. I believe it was 1.3
million.
1.1. It was some deductions.
Yeah,
The sale price 1.2, but then we had some deductions.
Do you remember when I took your deposition, you said that you received 2 wire transfers, one for $1 million and another one for $130,000?
No.
You don't remember that?
Why would I say this? I don't recall I received that number. I mean, I have the closing statement in front of me.
Just 1 second, Mr. Wagner.
To be honest with you, I go by the closing.
Yeah, but you told me, you don't remember telling me you received 2 wire transfers, one for $1 million and one for $130,000?
So how much will be total together? I don't get it. It will be over
total together was $1,130,000.
total
And
together.
that was after the deduction of $70,000, which you had agreed to take the price up to 1.2 million. You remember that?
I really don't remember. Or what I remember is what I see in front of me here in the closing statement.
So you don't remember that the price was taken up to 1.2 million, and then
I don't remember the 1.2.
You do remember?
You should have the closing signed by me. You should have it.
So two things. One, Mr. Kendall will share with you, Mr. Vaknin, whatever documents he wants to share. But two, you two are talking over each other. So Mr. Vaknin, please don't answer until Mr. Kendall's done with his question. It's not like Jeopardy where you can buzz in, but you need to wait until he's done. Then feel free to answer in any way you want, but it's real hard for the court reporter to take down when the two of you are talking over each other, okay?
I apologize.
No need to apologize.
Trying to put the deposition up. Let me go on, Mr. Wagner, with another. We'll get that document up in a second. Ms. O'Neill asked you about the value on the appraisal. That was exhibit number 32 she showed you, which was the appraisal. And you said that the 2.6 million that was shown as the as-is market value of that property was inflated. Do you recall that testimony?
Yes.
And do you today believe that that was an inaccurate depiction of the actual market value of that property at the time you entered into this agreement with Mr. Hyder?
I do believe that they're overpriced.
Okay. Would you believe that sometime during the next year that property sold for $3.5 million?
It could be.
Could be?
Yeah. 6 years after, yes, could be.
So then 2.6 million would not have been an inaccurate or an inflated number, would it?
Sir, I put it for sale about 2.5 months, let's call it 3 months before the sale went through. And I got 1.1, and you bring appraisal and he makes it $3 million. And I can tell you right now, impossible. I'm not that dumb. I could sell it $2 million. I could sell it $2.5 million. How it's possible something which worth $3 million from me going to sell it in 1.1? I mean, I'm not that stupid, isn't it? Why can't I ask even that higher price? But let me tell you something. I did ask higher, and I started with 1.5 and we went down to 1.3 and then we went to 0.1, and that was the price. That's again my opinion. That's my opinion. You're asking my opinion. It's extremely high the value. Now you're talking about today. The market today, that's what I said before.
Coming up.
If he
can
didn't,
So, Mr. Wagner, at the time you sold this property, you were under a lot of pressure from the city of Atlanta to do something about the dilapidated condition of this property. Is that right?
I don't know if you call it pressure, but we agreed. Either we'll find a group to fix it or sell it.
Yeah, well, you say you don't know if you call it pressure, but that's what you called it when I took your deposition. Do you remember that?
Okay, you want me to answer you?
Yeah, I want him to finish his question, then you can answer it.
Do you remember me asking you about this particular property? And you told me in the answer to my question that Donnie was a nice guy. He has a nice family, but I was under the pressure. I was under pressure from the city. I was under pressure from my family. Sell it fast. And that's why I think I was fair enough. I reduced it, but my asking price was 1.4, but it didn't happen. So I sold it to him. You remember that?
I don't remember, but I don't see anything wrong with what I said.
Okay, so you were under a lot of pressure. You said today you wouldn't use the word pressure, but when I asked you about it back in December 2018, you said you were under a lot of pressure to sell this property because of the city.
I didn't sell it because of the pressure. I sold it because I needed to sell it. You have to remember, I own this property from 2010. So enough, it's enough. We tried everything possible to do with the property, and that was the conclusion. I mean, pressure to sell it for a third of the price. I don't understand why you're leading to that point. I will never sell something with value of $3 million for 1.1, never.
Okay. Go to page 50.
What page?
50. Now, I was just asking you about how much money you received from the sale of this property pursuant to this agreement that you signed on April the 30th of 2016. And do you see that document on the screen?
It's not page 50.
Can you make it bigger?
Can you make it bigger?
Okay, what do you want to see?
I want you to look at
That's page 49.
yeah, it's 49. You on page 50 or 49? Okay. I was asking you about some text messages.
I'm gonna object to this level of impeachment. He's asking him about testimony about a document. He's got to show him the document.
Well,
No, I'm showing them.
if you want to stay focused on page 50, let's do that. But text messages and what's on page 50 aren't the same thing right now. They're wire confirmations.
Yes. Down at on line number.
So let's take down what's on the screen because jurors are reading it and we're not asking any questions about it.
Well,
But when you're ready to ask questions about what's on the screen, then let's put it up.
I'm ready to ask questions.
Okay.
You got it.
So while they're doing that, let me ask the juror something. It would be great if we got through Mr. Vackman's testimony today because he's dialing in. It's 5 minus 1 minute. Are you all, is there anyone who can't stay for another 20 minutes or so to see how far we can get in this? I know I'd said we normally stop at 5. We started late today, meaning 1. We started beyond that, but people good staying for a little bit longer. We won't normally do this because I think this is our only remote witness, at least one that will have it. Great. We'll keep going. If someone reaches a breaking point, let me know and I'll take everyone's pulse in a little bit. Mr. Kimball.
And I won't be that much longer.
I'm not saying you're taking a long time. It happens to be 5.
Yeah, I won't take that much longer.
Okay.
Mr. Vackman, look at my question there, and at line number 14, it says, and then a wire of 130,000 into an account at Bank of America for the seller proceeds of Verbena. And you say that's correct. We received that money. You see that?
130 plus, what was the other one?
Right above that, it's kind of disjointed, but.
Oh, all right. So together it's 1.13. That makes sense.
Okay, all right, that's all I was asking. And then when you add
No, I apologize. You were saying over $1.2 million, and I thought it's impossible because the gross 1.2. So that's numbers, it's correct, sir.
Okay, all right. So can we agree that you signed to these facts? You signed an agreement on 4/30/2016 to sell this property for 1.1 million. But you actually received 1.3 million.
No, not, I'm sorry to correct. It's not 1.3. It's 1.1.
I'm sorry, my mistake. 1.13 million, $1,130,000. You actually received $1,130,000 86 days after you signed this contract. Is that correct?
I didn't sign a contract and it just expired after 60 days. It's 3 weeks after.
Right.
And as a lawyer, you should know that. That's the deadline. It has to be deadline. Enough, it's enough.
All right. Now, at the time you agreed to sell this property, there were some taxes outstanding on this property, correct?
That's correct.
And you knew that there were taxes outstanding at the time you agreed to depart with this property.
That's
Is that
correct.
right? Okay.
Yes.
And you understood that there was going to be deductions for those taxes. Is that correct?
I don't know what exactly you are leading to. We did all these calculations in the closing. There was a number and it's finished. I cannot remember what was and was not. If you have any doubt right now, tell me what's your doubt about it. That was a few years ago and we paid the taxes and his lawyer made the calculation, which he presented me to, and it was the end of it. I cannot remember what and what's not.
Okay. At the time I'm gonna try this again. At the time you signed this agreement, you knew that there was some outstanding taxes on this property, right?
Some of those taxes I paid them in between the time that I was waiting for him to close.
Okay.
And I have the receipt. I can show them to you.
Now there was a debt of some $896 owed to the city of Atlanta. Do you recall that?
I don't recall. Where do you bring this number from?
Okay, and then there was there another debt of $127,000 owed to Fulton County for past due taxes?
That's correct, and I paid them.
Okay, and after this deal closed, what upset you about this situation after you received the $1,130,000 is that you got sued by Mr. Hyder and the people he sold the property to for misrepresentation of what those taxes were, right?
They were not suing me because of the taxes. Nobody sued me because of the taxes.
Nobody sued you because of the taxes?
No, I don't know what taxes you're talking. Who sued me for the taxes?
You don't recall getting sued and coming to court here in Atlanta?
But it wasn't for the taxes.
Well, what was it for?
I don't recall, but it wasn't for taxes.
But you recall getting sued, right?
Not by Atlanta.
No, you got sued by Mr. Hyder and Brian Dalton, John Dalton, and D2 Property Group. You recall that?
That's correct.
And do you recall signing a settlement agreement with Mr. Dalton and
That's
D2?
correct.
Right. And you paid them some money, right?
That's correct.
Okay. And as a result of signing that settlement agreement and paying them the money, you agreed that you would be obligated to testify in a case between them and Donnie Hyder, right?
I don't know where you bring all those details. I mean, I got advice from my lawyer to go ahead and compromise, and that's what I did. I follow his laws. I didn't go to those small details, and you're going all of those assumptions and whatever. It recommended me. Let's compromise the deal. Let's finish with it. I have respect to my lawyer, and I did it. If you have any questions, you can ask him directly.
But you remember signing that agreement, agreeing to testify, right?
I don't remember every line. I do remember that we settled this case and we made a peace with everybody, and that was the end of it.
And you made these payments in 2 installments, right?
I really don't recall, to be honest with you.
So let me ask you this question. You testified that you did not know that Donnie Hyder was selling this property to Brian Dalton, John Dalton, and D2 Properties. Is that right?
You see, now again, you're boiling my blood. This is not my point what he does if I sold him the property. He can do whatever he wants. The problem is he did everything wrong. I don't have the heart to. Numbers change. He put completely my name in so I can look bad. And no, trust me, I didn't see those people. He was the only buyer, the only guy I did the deal. You know what he was supposed to do if he was a small guy? Shake my hands and go flip it, sell it to them. That's it. But he didn't do it. He didn't do it. He did it in the complete criminal way, in my opinion. Don't do that. No, we shouldn't be here, all of us today. You should do it the right way. You should take his partners and tell them that's the deal. I'm buying it from him. It's a flip. It's okay. You can do that, but you gotta do it by law. What he did, he tried to screw his partners. That's my opinion. That's why all these dirts coming to the picture. I wasn't involved. I don't care. I finished my part with Donnie. I finished it. I don't have any issue with him. The problem is, now I find out why I don't have the hard one, why his lawyer, she's also involved with him, lying to me all this time. And now I find, I don't even think I know all the picture of what exactly he did. But I'll tell you right now, it's not kosher. It's not kosher. So now you're asking me to understand where is it coming from? No, I don't.
My last question to you is this. Since you never ever met Brian and John Dalton and had any dealings with D2 Properties, why did you sign a settlement agreement and pay them money?
Object to the form, misstates testimony.
I need you to state your objections more loudly and into the microphone. That's okay.
Object to the form, misstates testimony.
Why don't you, I was listening to the question and I see where you're going, but if you would restate it so I can analyze it in the context of that objection.
My question to Mr. Vaknin is, given his testimony that he never had any dealings with Brian Dalton, John Dalton, or D2 Properties, why did he pay them money in a settlement?
Okay, I've listened word for word.
That question.
No objection
No
to that?
objection to that.
Okay, you fixed it.
Sir, you are a lawyer and he's a lawyer, and I'm paying to listen to him. He's my lawyer and I have big respect to him. By the way, Michael, he's an excellent and an honest lawyer and I love him. Whatever he recommend, let me tell you right now, I didn't want it. I wanted to fight it all the way against Delph. I wanted to fight it. I don't know them, like you said. I never met them before. I wanted to fight it because I don't think they deserve whatever we agreed. But I listened to my lawyer and I like him. I think Michael is an excellent lawyer and I took his advice, even though I had to pay it from my pocket, extra money. I did it and I finished with that.
Thank you, sir. You answered my question. You relied on the advice of your lawyer. Thank you. That's all I have this witness.
Thank you, Mr. Kendall. Any redirect?
Briefly, I hope.
Sure.
Exhibit 3.
Mr. Kendall, you need to grab your laptop if you don't mind.
Thank you, Judge.
Definitely don't want me to be around that. Not displaying. Hopefully, Mr. Vaknin, I'm going to show you Exhibit 3. There you go. Exhibit 3 is an email that you got from Ms. Kimbrough on May 25th, 2018. True?
Correct.
Right? And it says down there, if you look at the end of the first paragraph, she's telling you at the time of the transaction, the buyer requested his loan terms to be confidential. So I
Thank you
cannot
so much. Thank you. That was, I was
provide the
looking
buyer
for.
settlement statement to you. I'm not authorized to disclose the buyer loan terms or anything related to their loan. Is this the email that you were referring to when Mr. Kendall asked you some questions?
Yes, thank you so much. It's exactly, and that's 2 years after we closed. I still don't have that. It's ridiculous. Thank you so much, ma'am.
All right, I want to also show you what we marked as Exhibit 1. And this is an email that we looked at before. This is another email that Ms. Kimbrough sent you on July 26th. And it has a revised HUD-1 settlement statement that she's sending you. You remember getting this?
Correct, yes.
Right. And if we look at that revised HUD-1, page 3 of the document deck. I'm going to pull out line 507 for you so you'll be able to see it. And I know it's a little hard to do. I want to get it big enough for you to be able to see it, but that means the jury can't see the rest of the document. You see here, it says overdue county property taxes. It's a little hard to read, but it looks to me like $49,594.43.
That's correct.
Is that what you understood were the overdue county property taxes on the Verbena property that you were supposed to pay by closing or at closing?
That's correct, ma'am.
Those are all my questions.
Mr. Kendall, anything else?
Nothing further.
Okay, ladies and gentlemen, if you have any questions for Mr. Vaknin, now's the time to jot them down on your handy dandy cards, and deputy will pick them up from you. You don't have to ask questions. It's not an obligation. Okay, stay there, Mr. Vaknin.
I'm sorry, ma'am. I'm sorry, sir.
Please stay on the call. I might have a few questions for you, okay?
Okay, sir.
Thank you. Thank you, sir. You don't have to fold them up.
What do you mean?
Bonus last minute question.
Huh? Oh, you ain't listening. No. Oh, man, you gonna have to, you gonna mess around here, bro. You keep me from the wrong people. You should be, yeah, man. It's about 400 people a day now. Now, that's down to 3,500, 4,000. Oh, yeah, I'm
All right, Mr. Kendall and Ms. O'Neill, if you would come to this magic door, I'll let you in. The question review center. Well, yeah, I want you to read all of them. And there are a few I remember asked and answered with an objection.
No, I know, I'm just thinking for real.
Well, so, three that I don't change to ask. The other one is a question. Mission. The rules are more directives to you. First two, they want to make notes. Those questions were asked. I don't know. Change that more to put that
Those are both good.
I think the other one. That's a question.
I often remove things that we did, so.
That's
Yeah. Crazy stuff. Sort of, someone didn't follow. Okay, thank you. All right. Oh, you guys stuck? Aha, the lawyers can't come back. Press the black button. And push. Great. We get through the trial much faster. All right. Mr. Vackman,
Yes, sir.
how many offers had you had for the Verbena Street properties prior to Mr. Hyder approaching you with an offer?
A serious one, and offers like, you have to remember, not only to sell it and run away. I had to think also about the community. So it's very important to find someone who can buy the property and also fix it, not to buy it and leave it the same way happened to us. So really few of them, but Mr. Hyder was the strongest one. Again, based on the information he gave me.
Okay, when you say few, is that 5 or 100? As best you can recall, how many offers that you viewed as serious offers had you had before Mr. Hyder approached you?
Maybe 2.
Okay. Prior to Mr. Hyder approaching you about purchasing the property, how long had you owned it?
2016, it was 6 years.
When you purchased the Verbena Street properties, what state of repair were they in?
Well, the property was after the hurricane, and it was completely destroyed. So it needed completely repair. It's completely not only cosmetic. It has to be very, very heavy work supposed to be done.
And that was the way it was when you purchased it?
That's correct.
Okay. Did your 2 LLCs, Atlanta Beverly and Atlanta Plaza, did they own any other property besides the Verbena Street property?
No.
And did either of those LLCs carry on any other business besides owning those properties?
No.
Is it your testimony that you understood your deal with Mr. Hyder to be that the closing would happen in 15 days?
That's correct, sir.
So you've seen the document that says 60 days on it. Is it your testimony that 60 days was written on after you signed, or was it there when you signed?
To be honest with you, I don't remember. I disagreed to anything above 15 days. I said very clear, we wanted to close in 15 days. There was nothing to do. I mean, if he has the money, The title was done, everything. It's not complicated. And he
Okay.
agreed to that.
Was there any particular reason that the earnest money was $5,000 for a purchase of over $1 million?
So I don't understand, sir, the question. Why was it too little, or why was?
Well, I don't know. You may have thought it was just right, but the question is why $5,000 for a large?
Again, it wasn't me. It was him. I didn't even know. He paid me cash, 5,000. I don't know.
Is that how the earnest? I'm sorry to interrupt.
My point was, I didn't ask for deposit, and it wasn't planned to ask from him. He just said, "Here, I wanted to show you that I'm for real." So he took $5,000 cash, and I took it.
Okay. In your experience as a real estate investor, have you been involved where an appraisal of a property you are interested in buying is done without the property owner's participation or knowledge?
Never. It's very, very important the owner will be there for many, many reasons. Many reasons: security, insurance. Not only that, guiding him where to go. It's a big property. I don't know. I think it's 7 or 9 acres. So you cannot. And I wanted to mention also, Your Honor, it was very dangerous area at my time. So it just doesn't make sense for appraisal to go by himself.
Did Mr. Hyder ever present to you, when you were working out with him, the details of that contract you signed, any letter from a bank or anything indicating that he had financing lined up?
He showed me his bank. I forgot what bank was it. He showed me in his bank over $6 million, $6 million and some change. That's what, when he left, I told my wife, thank God, we have the right guy.
Does your wife ever sign any of the documents relating to real estate transactions for Atlanta Plaza or Atlanta Beverly?
I don't recall specific, but most time I did it. She gave me the power, but sometimes when she needed, she would sign.
Okay. Thank you, Mr. Vaknin. Ms. O'Neill, do you have any follow-up questions based on what Mr. Vaknin and I just talked about?
I do not, Your Honor.
Mr. Kendall?
No, sir.
All right, may Mr. Vaknin be excused?
Yes.
Mr. Vaknin, thank you so much for your time. You are free to go.
Thank you so much, sir, and I appreciate it. Thank you very much.
All right, bye-bye.
Thank you. Bye.
All right, Mr. Vaknin is gone. Ladies and gentlemen, we are going to pause for the day, meaning stop. You will be able to go home. Thank you for staying a little bit late. Tomorrow, we'd like to start as close to 9 as we can. I'm going to have the lawyers get here a little before that so we can work through whatever we might need to work through. As is always the case, we cannot start till all 14 of you are here. So do your best to be on time. The dynamic will be a little different. Getting here for 1 o'clock, no traffic. The shuttle runs less frequently, so those cut in opposite directions. The shuttle will run, I think, every 15 minutes in the mornings until about 10, but you'd be late by then. But it's a little harder to get downtown as plenty of businesses have emerged from the pandemic. And I can tell you the connector traffic gets a little thick. So plan accordingly. And if you're running late, call that magic number and let Ms. Hansberry know that you got stuck so we don't panic. Finally, and most importantly, beyond having a good night tonight, remember, no outside research. So don't get online to research something. You see how this works. You have a question, and if it's a proper question, it gets posed to the witness. So you shouldn't do any research, and you really need to refrain from sharing with anyone what the case is about. You can say you've got a great judge, it's a nice courtroom, and you'll tell folks more later, just so you don't get something unintentional from someone who says, let me tell you how these things really work. because they don't know, because they're not here for this case. Does anyone have any logistical questions before I let you go for the night? I want to observe, I noticed a couple of you stood up to stretch, and that was perfect. It was not disruptive for any of us. So if you need to stretch, do what you did. And we took a break when I polled you all and someone said they needed a break. Tomorrow will be a lot like today, minus the opening statements. We'll have the next witness from plaintiffs, and we'll keep pressing. There'll be a lunch break. Reminder, if you choose to bring your own food, don't bring it in anything glass, and you need to bring plastic cutlery if you're bringing cutlery. Otherwise, you'll be able to go out and get lunch, and you're welcome to bring it back and leave all your stuff in 8E. If there are no logistical questions, if you go with Deputy Gordon, thank you for your time, and we'll see you 9 a.m. tomorrow. Be safe. Oh, they're gone. Great. I want to get on the record that every card submitted will be made part of the record. So this will be, I'm holding in my hand right now, the first 11 cards. This will be Court's Exhibit 1, and it will continue to grow as questions are submitted. I don't throw away the cards of questions that are not asked. I want to make the record complete. So every submission will be part of Court Exhibit 1. Ms. O'Neill, any logistical questions, concerns, and you all can be seated if you want. I'm going to stand because I've been sitting too long today.
We would ask that council does not ask our IT or.
I'll get to that. That's on my list. Anything else?
That was my only one.
Okay. Mr. Kendall, anything we need to work through other than how exhibits are going to work before we wrap for the day?
No, I do just, there was one question that I wanted to ask of Mr. Wagner that the court decided not to ask, and I can't remember the number of it, but.
Sure. The one about what was the purpose and intent of holding on to the Verbena Street property for years, underdeveloped and a blight to the community?
Yes.
And so the record is clear. I elected not to ask that because I deemed it to be irrelevant. Mr. Kendall asked that it be asked of the witness, but it was not. Thank you for flagging that. Anything else?
I need to know what Ms. O'Neill's schedule is, since I'm under the obligation to notify Mr. McGuire and Mr. Fowler 24 hours before that testimony is needed. Unless I know. And even then, I mean, she may take longer, shorter period of time.
So two things on that. I'll ask in a minute. It's a rule of reason. You know, if you're reaching out to Ms. Whitlock saying it's noon and you need them there 9 a.m. the next day, that's fine notice. What's not okay is at 8 p.m. saying they need to be here tomorrow morning, unless that's when you got notice. And then Ms. Whitlock needs to be unhappy with me and with Ms. O'Neill. Second thing, my understanding is that tomorrow is 100% plaintiff testimony. So we can take stock. Well, but I guess to your point, if they thought they'd rest at noon on Friday and you wanted to have either McGuire or Fowler testify Friday, you need to know that so you could let them know Thursday some point. Okay, so where crystal ball
I
it.
expect to be done on Friday.
Okay.
Exactly what times and determine how long it takes tomorrow.
Okay, so why don't you, Mr. Kendall, let Ms. Whitlock know that I don't know in which order you're going to call your witnesses. But if you're going to front load those two, then it's possible that they would need to be available Friday after lunch.
Okay, I really have, I think, 5 witnesses. Fowler, McGuire, Kimbrough, Hyder, and Andrews, George.